Here, the Court of Appeals of the State of Michigan is now in session. The Honorable Christina Robinson Garrett, the Honorable Philip P. Mariano, and providing the Honorable Michael J. Curtis. Here for the country. Have safety.
Thank you, Vince. You can sit down. This is my first order of the day. Well, welcome. I see a lot of old pros out here. Goes without saying, you don't need to read your brief or rehash the facts. That's all we do around here is sit around and read and write. I think Judge Mariani has a standing desk, so he stands and reads and writes.
Dirty dream.
Yeah, but that's all we do all month. So you don't need to rehash everything. Don't get up here and read for 30 minutes. Just get to the heart of the case and we'll move on. We got a full docket. And as I told people yesterday, if ends up everyone goes a half hour, I hope you bring your sleeping bags because we'll be here really late tonight. All right, without further ado, we'll call our first case, number 18 on this month's docket for us. Case number 372004, People versus Brandon Scott Knight. And I think Mr. Strauss is remote. Mr. Strauss, are you there?
Coming. Yes. Do you see me?
Oh, yeah, I see you.
Oh, great.
All right. You're the appellant, so have at it.
Just briefly, I was essentially relying on the brief, of course. I just reiterate that both OV 4 and 10 must be based on the sentencing offense. And the judge didn't articulate how at all the scores related to the sentencing offense, disseminating the photograph. And it doesn't appear that
Isn't it a videotape?
or the video. It doesn't appear that relied on any kind of vulnerability. The whole event over the course of time would possibly support that, but that was not the sentencing offense, and the same thing would apply to OV4. And then I might add, of course, I would agree with the prosecutor who pointed out what I apparently missed, that the sentencing guidelines were not changed on the sheet as they should have been from OV10, I believe, from 15 to 10. But that's really all I have to say. I could reserve time for rebuttal if it's even necessary.
Okay, you have about 29 minutes for rebuttal.
Take every minute.
So that was a good catch for a retiree. Go ahead.
Good morning, Judge Reardon. Maryland Day Assistant Prosecuting Attorney representing the people of the state of
I
Michigan.
thought you retired.
I did, but all good prosecutors come back part-time, so you should know that by now.
You retired on a Friday or contract worker?
I was no, it's not a contract. For Oakland County, we're actually part-time county employees, which is
really?
good. So I don't have to worry about all the extra taxes there, but
At
yes.
the federal level, all these agents leave on a Friday and they're back in their state.
No, I took
as
3
a
weeks off.
contract
I had 3
employee.
weeks off.
Yeah,
So,
Monday, but go
yeah.
ahead. I'm sorry.
Your Honor, OV 4 and 10 were properly scored. The court did not, it was not clearly erroneous in those findings. As far as the catch on the scoring, I admit there was error in the scoring. I raised it in my brief, hoping the defense counsel will file supplemental brief on the issue. I don't really like to be the one saying, something messed up. So, if defense counsel wants to file supplemental pleading, because the only way he wins is if there's a finding that the trial counsel was ineffective because trial counsel waived the issue because he specifically said the guideline scoring did not change.
But is there any way that counsel would not have been ineffective in that respect? It's a very clear
it seems to be
here.
very clear, but we as prosecutors
I
get
understand.
upset when courts raise issues that weren't raised by the appellant. But yeah, it is pretty clear that this was an improper scoring in this case. And even if this court, if it goes down, it's going to go down. The sentence is still within the corrected guidelines, but under Francisco, it would have to come back. But even assuming if that happens, even if say like OV10 was improperly scored, you would still have the same, there would not be no problem because it still would fall within the guidelines. And as far as prosecutorial misconduct, there was no prosecutor error in this case. defendant's count or defendant testified and the prosecutor was just impeaching the defendant with what prosecutors can do when the defendant testifies. So it asks his court to affirm the conviction and do with what you will with the sentence in this case.
Well,
Answer any
do we
questions.
have to remand it? I mean, the court can give the exact same sentence if we remand it, correct?
Correct, absolutely, because it's within the guidelines.
Right.
You know, if you're looking at Francisco, they said if there's a error in the guideline range, you have to give them an opportunity, but you don't, it's not remand for resentencing. It's remand for basically, I think, articulation that they would impose the exact same sentence. I believe that's what Francisco said. I could be wrong. I haven't looked at Francisco for a while. But the guidelines do change, so that you have to give the court the opportunity to look at the corrected guidelines for this, to determine whether you would give the same score.
Okay, any questions?
No. Thank you.
Thank you.
Go ahead, Mr. Strauss, rebuttal?
No, I'd agree if the court would like a supplement, but I think that's plain in the record and, you know, with some embarrassment. I admit I missed that, but I also to reiterate that I believe OV4 and OV10 were misscored. They did not relate to the sentencing offense, which was disseminating the picture that did not cause any psychological, effects from that. And the same is true, I think, with OV10. They looked at everything that she testified to, but that did not pertain to the actual sentencing offense. So I think the case should be remanded. So the court could articulate if it has a basis for scoring OV4 and OV10 as it did, and also if the guideline change would affect the sentence.
Well, we may be able to see what Judge O'Brien thinks about it. Okay, any other questions?
Nothing from me.
All right, thank you very much. Case is submitted.
Thank
Have a
you.
good day.
Yes. Thank you.
Calling number 19 on our docket. Case number 375550, People versus Kenneth Michael Nordstrom.
Yeah, Your Honor.
Yes, you may.
Good morning, Your Honors, and may it please the court. I'm Megan Stammel. I'm here on behalf of Kenneth Nordstrom. Mr. Nordstrom would have liked to have been present, but unfortunately, I guess it wasn't possible to coordinate that with the jail this morning. Your Honors, I know the court has had ample opportunity to review the briefing. We do appreciate that leave was granted in this case. A few things that I wanted to address during my oral argument. I think really this case comes down to whether the detention that the officers engaged in was tantamount to an actual arrest. And we believe that it was. I think an important case is the People versus Lewis case that I cited in my brief, which stated that when the police detain a person for investigation of a crime, they are in fact admitting that there is a lack of probable cause that the individual committed the crime. And I believe that's what we had in this particular case. As it relates to the so-called detention of my client. At the time, they stated that they performed a pat down of Mr. Nordstrom's person. The record is clear. All he was wearing was pants. He wasn't wearing a shirt. And that after that initial pat down, when they did not find anything of concern, they took him to the patrol vehicle, searched him again, and then were trying to place him into the patrol vehicle.
When did they cuff him?
When did they cuff him? I believe that was as they were trying to place him in the patrol vehicle. However, the record is limited to the transcript at the preliminary exam, which is fairly sparse as it relates to an exact play-by-play of how things happened. Although an evidentiary hearing was requested, if needed, by the trial counsel, no evidentiary hearing was held. The prosecution states that there are circumstances where an individual can be detained and that they could be placed in a patrol vehicle or placed in handcuffs. However, the cases that are cited by the prosecution are very limited in their scope. They're not factually similar.
How about officer safety?
Officer safety is, of course, a concern. However, the cases that address officer safety that the prosecution cited are under circumstances where there was a clear sense that the individual they were interacting with might be dangerous.
So we have an intoxicated individual. The 911 call was harassing women, investigated possible disorderly conduct.
But-
You know, you don't know what you're dealing with as an officer. Isn't that correct?
That's correct. However, at the time that they engaged with Mr. Nordstrom, he wasn't acting in any sort of dangerous fashion. He was sitting behind a dumpster with his dog.
With the officer in this case, didn't he testify that when he located Mr. Nordstrom behind the dumpster, he did not observe him engaging in any unlawful or bothersome activity at that immediate moment? That was his testimony.
That's correct. And the cases that the
They
prosecution,
were there because he was unruly, correct?
they were there because they received a 911 call.
Exactly.
From-
So when you're going in as an officer, you're thinking, okay, we don't know what we're dealing with.
Correct.
All right.
However, they did have an opportunity to pat down Mr. Nordstrom. They found nothing dangerous on his person. And unlike the cases cited by the prosecution where the courts found it was appropriate to handcuff or to place those individuals in a patrol vehicle, those cases were cases where a handgun was located. They were investigating a felonious assault involving a gun. Execution of a search warrant with multiple individuals. None of those factors were present in this case. The police were there to investigate a possible 90-day misdemeanor, non-violent misdemeanor, and they did not observe Mr. Nordstrom acting in any type of disorderly fashion upon their arrival.
And so then they just kind of held him, essentially detained or arrested. I guess it will be decided. And for a possible disturbing the peace call that they received, but they were waiting to get a written statement from a secure caller, right? So they're just waiting. They just kind of have him.
Correct.
Okay.
And so based on the fact that they are waiting for that additional information to get them over the line to probable cause, they placed Mr. Nordstrom, they detained him, which is tantamount in this circumstance to an actual arrest.
Counsel, can I ask you about, I mean, then a bunch of other stuff happened.
Correct.
And I mean, is it your position that, let's assume it was an arrest and let's assume that there wasn't a lawful basis for it at the outset. Is it your position that everything that he does after that, with respect to other officers he later engaged with in the jail, the med tech, all of that also gets wiped away by virtue of that one piece, or are those separate freestanding offenses?
I think that they would all be part and parcel of that same unlawful arrest.
Is there, and if it's in your brief, just point me there, but do you have particular authority that helps me know that's the right way to think about this?
I don't. I can provide that to the court with a supplemental brief.
I guess adding on to Judge Mariani's comment is at the preliminary examination, he's bound over on these charges, right? He has 5 charges.
Yes.
And so is it your position that if the, I don't know which charge it would be, disturbing the peace, because all the other charges kind of stem after, that's the initial charge, right?
Correct.
Okay. Is it your position that if there's no probable cause to bind him over on that charge, then the other charges, he shouldn't be bound over as well? Or is it your position that at the trial court level, at the preliminary examination, they need to be able to find probable cause for each of those charges? And if they have it, then he's properly bound over? Does that make sense to you?
If you can just please rephrase that.
So, at a preliminary examination, you're going to be bound over by the charges, right?
Correct.
Probable cause. And so I'm asking, he has 5 charges before the trial court judge for the bind over, correct? With the preliminary examination. What is it your position that they need to find probable cause for each of these charges at that time? Or if the initial charge, if these other charges stemmed from this initial charge or happened after this initial charge, as Judge Mariani just stated, that if they don't have probable cause for that disturbing the peace charge, that the rest of them are gone?
Well, the testimony at the preliminary examination would have been limited to the felony charges,
Mhm.
not, most of the district court judges won't
Right.
won't allow,
Okay.
for relevancy purposes, a tremendous amount of testimony as it relates to the misdemeanors. So the focus really was on the alleged resisting and obstructing at the district court preliminary examination level. Although the district court found probable cause on the resisting and obstructing charges, the fact that I guess there's kind of two issues. The first is it was a violation of Mr. Nordstrom's constitutional Fourth Amendment rights to be placed under arrest. And so we are asserting the case should be dismissed with prejudice for that reason. However, in the alternative, if the court, I guess, is not satisfied with the record that was created at the district court level, we're also stating that the prosecution at that district court level needed to prove probable cause as to each element of the charges. And that includes the fact that the officer was engaging in a lawful action at the time of the alleged resisting and obstructing. And so that would include, and so that would have been an element that the prosecution needed to establish that they did not at that preliminary examination stage.
Thank you.
And so I don't think I have anything additional. I would reserve my additional time for rebuttal.
You said there were two pat downs, correct?
I'm sorry?
There were two pat downs?
Correct.
All right, was the defendant cooperative during the pat downs?
I don't believe that's part of the record.
Thought there was officer testimony that said he was not.
I know that it stated he was not cooperative during the second pat down. I don't believe there was testimony regarding the first pat down. Thank you.
Good morning. Rayanne Ruddy, Assistant Prosecuting Attorney, appearing on behalf of the people. I'm going to primarily rely on my brief. However, I want to address a couple things. And starting with the question that you had, Judge, just a moment ago. Yes, there was resistance from the whole thing. This is a situation where the police are called to a disturbing of the peace or a disorderly person. The evidence, or I'm sorry, excuse me, the information that had been gathered was that there was a shirtless man in the parking lot screaming at people, harassing women and looking for a fight from anybody who was willing to engage in. So it was a violent
And when they found out he
situation.
wasn't sitting down, he was laying on his side with his dog.
Correct,
there.
Your Honor, he was. Now, I would concede that the disorderly person or the, or whatever the charge, disturbing the peace, had ended at that time, but as soon as the police arrived, a whole new one started. The defendant immediately got on his defenses and said, you can't touch me, you can't touch me, you can't approach me, you're not allowed to be here, I don't have to answer your questions. And he was actually screaming loudly. He was still disturbing the peace at the apartment building because he wasn't doing this calmly. He was doing this very loudly. It was very clear that he was talking to a police officer. So we would maintain that the disturbing of the peace still exists in that defendant did not calmly talk with the police as he's required to
Can I
do.
just ask? I mean,
Yeah.
and I don't know if there would be, but is there any authority that, helps me know that the facts that you're describing are in fact adequate for purposes of these misdemeanor offenses? Obviously, speak, raising
I
your
don't-
voice, all that sort of stuff. I mean, I understand what you're saying, but I'm curious about how.
I right off the top of my head, I don't, and I apologize. But what I would refer you to would be the definition of disorderly person. And he meets the criteria of that. He's clearly intoxicated. He's clearly making noise. He's clearly disturbing everybody in the immediate
That's
vicinity.
statutory definition.
Yeah, under MCL 751-167E. And that is a disorderly person. Drunk is a person who is intoxicated in a public place and who is either endangering directly the safety of another or property or is acting in a manner that causes a public disturbance. So, had he been quietly resisting, had he been not making a scene, then the argument would be stronger. But in this case, he had committed another one.
And is that
He didn't-
because it's a public disturbance, what he was doing? Is that
Correct.
what you're arguing?
Yeah,
also?
he was in a public place and he wasn't far from where the original disturbing of the peace had happened. He was in the same parking lot. He was just behind a dumpster. in the same parking lot, and people were still around as well. And also, so the police also, judges, I think you pointed out, the police have information that we have an erratic individual at the very least. We have somebody who's screaming, looking for a fight. So when the police arrive, they don't know what they've got. They don't know that he has, whether he has a weapon or not. They don't know anything about it. And under Terry, which has been around forever, a police officer is allowed to approach an individual and to find out what's going on. And in this case, he did that. He tried to talk to the defendant. The defendant was very, very uncooperative. He was not answering questions. He was arguing. He was not making the officer's life easy. And his behavior didn't get any less erratic at that point. So at that point, the officer does have the authority under Terry and under other cases for Michigan that allows him to try to detain him. And that's what they tried to do in this case. They put him in handcuffs. They patted him down. They patted him down as a Terry pat down. So they didn't go for they don't have to look for everything, but they're looking for a weapon or something that could cause danger to them. At that point, he became very resistant. He was kicking and punching and throwing elbows and very uncooperative in getting him to put the handcuffs on and very uncooperative in getting him to the patrol car. And that's when all of the other resisting obstructions and the malicious destruction of property and all the other events took place, eventually with the EMT arriving and also having an issue with them. So I think that you have to look at this in its parts. And the fact that, and this was a good point, Judge Garrett, that you brought up, is that the people, I think you said that the individuals were waiting for the report from 911.
Mm-hmm.
That's not, it becomes irrelevant because the behavior that had already occurred. So in this particular case, the police were not relying on that. That was only what information they had gathered. But where the original disturbing the peace and where they had the reasonable suspicion to discuss and talk to him was at the point where he was acting out behind the dumpster when they first approached him. So he was actually disturbing the peace twice. One that was witnessed by witnesses, one that was witnessed by the officer. So we get to the point where the police have no other choice but to put him in the cuffs. He was resisting the second pat down, which is, I think, the question that you asked about, did he resist both? Yes, he did. He resisted the pat down. He resisted the handcuffing. He resisted the car. He was resisting the entire way. So it was and remained a dangerous situation for those police officers because of the defendant's erratic behavior. And Judge, the excellent question that you had asked was, does he get freebies? And no, he doesn't. Just because the first disorderly person had already concluded, he doesn't get to then be disorderly to the police officers. He doesn't get to be resistant to them. He doesn't get to elbow them. He doesn't get to resist putting handcuffs on. He doesn't get to resist these things after the police had already established probable cause that he had actually, reasonable suspicion for purposes of the disorderly person, and then probable cause that he was actually resisting the officers, trying to calm the situation. And he was the reason why the situation remained dangerous.
Ms. Campbell makes what's similar to a fruit of the poisonous tree argument, saying, the initial arrest was bad, so everything flowing from it is bad.
If that was the case, if there was an illegal arrest, if there was an improper situation, then perhaps then the Wong Sung case would apply. That's not what happened here, though. We had a situation that it was a very fluid situation. The facts changed from second to second, from moment to moment. And those police officers had a duty and an obligation to get to the bottom of what's going on with this man in the parking lot of an apartment building where many people live, where people are trying to go into their homes. They're trying to enjoy the evening. And this man is threatening fights with anybody who will fight with him. He's harassing women who are walking by, which of course.
But to be clear, that was the content of the call.
Yes.
not the behavior that was directly observed.
Correct.
Is that right?
That's correct. Yes, yes. But there could be, I mean,
Well, I understand. Yeah.
yeah, I'm not necessarily saying that that disturbing of the peace couldn't be prosecuted, because I think it could. I think we have a lot of evidence that that disturbing of the peace had concluded, but it was also something that had happened, and just because the police aren't there to witness it doesn't mean it didn't happen. So we opted to take a different approach, and I think we're using all the facts from that, plus all the facts that the officer experienced personally with defendant. And those are the things that brought up his yelling, his screaming, his refusal to cooperate at all.
So I have a question.
Yeah,
Can you opine on whether you think the police can detain someone if they have no authority to arrest them?
oh, under Terry, they do. Yes, they do have the authority to, but there is, requirements. There's criminal activity afoot. There's circumstances coming from, what they know from other officers. So it's very fact specific, but yes, absolutely,
Yeah, I think
detentions.
This case is very fact specific on what happened during that initial
Yeah,
encounter.
correct.
That
Yeah.
this case comes completely down to that.
Yeah, I think it would. It does, but I think that we even reach the point of probable cause, just in, his actions that occurred in front of these officers. In addition to all the additional other evidence. And I believe I cited to a case, if you'll indulge me. No, I don't want to waste the court's time, but I believe I did cite a case in my brief that does answer that question, Judge.
Okay.
I appreciate the question.
Yeah, thank you.
And I'm happy to take any other questions the court
I'm
may have.
happy.
Well, nothing further from me.
Thank you.
Darrell.
Thank you very
Thank you.
much.
Thank you.
Rebuttal?
What I would like to direct your attention to would be, I guess, when reviewing this case, would be the record that we have. The record is very, very limited. We have 4 pages of the preliminary examination transcript that discuss the officer's arrival at the scene up to the point that Mr. Nordstrom is placed in the patrol vehicle. That's pages 9 through 12 of the preliminary examination transcript. I think
Okay,
that,
I'm looking at the preliminary examination. I got 42 pages.
I know, I'm saying that when.
All the nine pages are relevant.
Correct.
Okay.
Only these 4 pages are really
Oh,
relevant
okay.
to
I get you.
the issues that we're advancing.
Okay.
I think the prosecution improperly is trying to add in additional facts in support of their argument that Mr. Nordstrom was potentially dangerous. However, there's nothing within the record from the trial court level that suggests that. The prosecution has stated that Mr. Nordstrom was threatening fights. That's not it contained within the officer's testimony as it relates to why he was dispatched to the location on page 9 of the transcript. There's nothing about Mr. Nordstrom engaging in disorderly behavior towards the officer up to the point of him being taken to the patrol vehicle in that transcript. And so based on that, based on the limited record that we have, the facts support that it was unlawful to detain Mr. Nordstrom under those circumstances.
We have a transcript of the 911 call.
No, that was not obtained or provided at the trial court level.
If the officer talks, I think, actually in your cross-examination about the 911 call.
Correct.
Okay,
I'm sure one could exist, but it was not part of the record.
okay.
And I think I would ask also the court to also consider the case of People versus Lewis, which is what articulates the test for determining whether a detention is lawful. And again, based on the record that we have, those factors, the preventing flight, minimizing the risk of harm to an officer, and facilitating an orderly completion of a search, recognizing that the list isn't exhaustive, but using that as a guide, those factors have not been met based on the evidence that was presented at the trial court level.
Now, that's a 1987 case. Do you have anything more recent than that? Does court articulate anything since then? That's all right. I can check it out. Don't worry about it.
I don't have
It's
that
still
handy.
binding. Well, it's still persuasive, so,
Correct.
yeah.
And the factors of detention are in the facts of this case are so factually dissimilar to cases in which the court has upheld these detentions before a traditional arrest that this court needs to reach a different result, that this was not just a mere detention, that it was tantamount to a traditional arrest. The cases cited by the prosecution, United States v. Hensley, that involved a passenger in a vehicle who was a felon with a gun sticking out under the passenger seat. The case of People versus Nimeth, there was a suspect of a felonious assault who was armed with a handgun. The case of People versus Green, where the suspect had approached the officers with clenched fists and was being aggressive and hostile towards the officers. And the case of People versus Zuccarini, where there was a large group of people during the execution of a search warrant and they needed to obtain control over the location to effectively execute that signed search warrant. Those factors are not present in this case based on the record that was established at the trial court level. And therefore, we ask this court to find that the detention of Mr. Nordstrom did rise to the level of a traditional arrest, that it was unlawful, and that therefore the alleged activities that occurred beyond that point were fruit of the poisonous tree, and therefore the case should be dismissed. I would invite any additional questions. Thank you.
Nothing further from me.
Thank you very much.
Thank you
Case
both.
is submitted. Have a good day. On case number 20 on our docket. Number 20 on our docket for today, in case number 371551. People versus David Rashad McCrackens.
Good morning, Your Honors.
Good morning, Mr. McCarthy.
Michael McCarthy, P30169, appearing on behalf of the defendant appellant David McCrackens. Your Honors, I never received, and I guess none was filed, a brief from the prosecution. I checked the docket entries this morning to make certain that I hadn't missed it, but it doesn't appear that any answer was filed.
I don't have one.
Very good. Then at least I don't have anything to respond to in that fashion. I raised two issues in this brief.
Your client filed a standard 4 brief, you know that.
And he did,
Okay.
yes, because I believe file a motion in order for him to be able to do so tardy. And I appreciate the court's granting that motion, and that was entered last month. I mean, the order was entered last month. What I would like to just focus on briefly, and I know what you said, Judge Reardon, in the beginning, you've read everything. In question number 1, I think that, you know, the standard when you're talking about the admission of evidence, the standard of review is abuse of discretion. I submit that this does constitute an abuse of discretion for a couple of reasons. One is
You're talking about the police officer testimony as to
yes,
what was said. They say was, you know, he was explaining why he took investigative steps.
that's correct.
Yeah.
Except that he put in the information that those people provided. And what I've argued, and I believe is the correct way to proceed, is based upon your conversation with witness X, what did you do next? Not what did this person tell you? And the reason why that's significant is because those people were listed on a witness list, but I've attached Exhibit A to my brief, which X's off or puts an X next to the people who are the actual trial witnesses. And why is that significant? Because none of those 3 were checked off as actual trial witnesses. They were not endorsed. When it came to presenting that evidence, defense counsel properly objected to it. And it isn't something with a minor impact on the outcome of the trial, because that was corroborative evidence upon which the assistant prosecutor relied when he made his closing argument. And I've laid that out in the brief also. So this is not just some little tiny evidentiary question that could go either way. This is, I submit, an abuse of discretion. And if it wasn't readily apparent that it was an abuse when a ruling was made, it certainly became apparent in closing argument. The better way, I mean, the way that it should have been done is all three of those people should have been there to testify. One of the things that the officer said prefatory was, you know, when he arrives on a scene, some people, they're not cooperative. He doesn't chase them down. He does let the people who are cooperative come to him, and then he takes information from him. Well, if that was the case with those three witnesses, why wasn't somebody out looking for them to give them a subpoena? Because according to what the officer testified, they did provide contact information. So this is, I think, something that really had a negative impact on the outcome of the trial, that had those people been present and subject to cross-examination, it may not have been testimony that underscored what the argument of the assistant prosecutor was in the end, which was that they saw this white Kia driving away with a white driver and a black male passenger. Who knows what everybody would have said had they actually been there, taken an oath, and sat on a witness stand subject to cross-examination. So that is, for those reasons, I submit it's an abuse of discretion.
Thank you, counsel. So this testimony, it was cumulative of Coleman's testimony and the video evidence that was presented, right?
There was video evidence presented
In addition to Coleman's testimony.
and Coleman's
So
testimony.
like, considering you have those two things, do you think that this error would be, would not be harmless?
Yes, and the reason is because Coleman is a cooperating co-defendant, and he makes a deal. And his deal is to provide truthful testimony. Now, the question is, how truthful would that testimony look had those three witnesses testified about exactly what happened?
Well, I mean, I guess the other scenario is that they don't testify and we just don't have those statements from the officer about, I got these tips and we didn't go. So if you just omit those from the record, let's say,
Yes.
again, how does that meaningfully impact, I guess, the core evidence that was presented in favor of a finding of guilt, or your client's theory of defense?
It would impact it because the closing argument upon which the assistant prosecutor relied, that evidence
Sure, well,
upon which he
let's take
relied.
out that part of the closing argument too. I'm just trying to, I understand that they put it in and then they talked about it. But then, if you just look at what else there was, why did these pieces about just what the officer heard and then did actually make a difference to your client's theory of defense or to the core body of proof of his guilt?
Well, that is a question that I think is best answered at a new trial where that evidence is not presented.
Well, we
I
have to
don't
answer that
know the
question before
answer.
he gets to the trial.
Pardon?
So we have to answer the question enough before we can get to the new trial. So that's why
But
that's my
I
question to
submit
you.
that this would have an impact because you don't have anybody coming forward saying this is what happened. You have a person who's got some baggage of his own and a keen interest in being believed about what happened and what he didn't do. And I didn't know anything about a gun. I never saw a gun, all that business that Coleman testified to. That would all be at issue a lot more rather than having this corroboration.
But what did the video, I guess, as Judge Garrett mentioned, there's video. So what did this hearsay testimony say that the video didn't show?
Well, I think that what it's saying is that there were people there.
A white SUV with a white driver and a black passenger. So
And-
how is that materially adding to what the video showed?
Well, a black passenger isn't necessarily Mr. McCracken's.
Well, and I also don't think this is necessary. That's not what the hearsay comment said, right? They just identified two occupants of a certain colored vehicle of certain, collections.
My point of my answer to that question was does the video identify Mr. McCracken's? And I think the answer to that is no. That's where Coleman comes in. And there is where the cross-examination of those three corroborating witnesses, I mean, the people put this case together. They had a real good game plan about how they were going to do it. And in the end, which also goes along with my second question here, but in the end, they were the beneficiaries, the people were, of having that evidence in the record, and they thought it was significant enough to argue it in closing. I mean, there's a lot of stuff that happens during a trial that doesn't end up in closing argument, at least not in mine. And I think that that is a significant point. And that's why, when I put this together, I thought this is really, it does constitute an abuse, which I understand is the highest threshold for an evident or for an appellate issue. Do you have any other questions regarding question one?
No, I think I understand your position. Thanks.
Thank you.
Thank you.
As to question two, I submit, and I've laid it all out in there, and I don't want to just reiterate everything I wrote, but I've never seen anybody that was less prepared to try any case, let alone a first-degree premeditated murder case, than this individual who tried Mr. McCracken's case. It's just one error after another. And, the essence of trial practice is an understanding of the rules of evidence. There's other things that you need to know too, but that definitely is something that you absolutely have to have the ability to articulate. And his comment that, well, I just don't remember the numbers, that's the kind of a thing that when you're taking evidence in law school, you cram into your mind to remember what those numbers are. And I have the advantage, I guess, of spending 45 years practicing law and having a pretty good amount of understanding of the rules of evidence. But the fact of the matter is, every time I'm going to try a case or look at a legal issue, I've got the book out. I'm trying to figure out how this applies and, find the correct out of 24 exceptions to the hearsay rule that applies, those kinds of things.
We have to hold them to your standard. I have experience with you, and there's no doubt you're an exceptional criminal defense attorney.
I anticipated that you might answer that question. I appreciate the compliment. No, I don't think so. I think you just have to show up being ready. And there was too much. The thing that really underscored it for me, it wasn't just, I don't know the numbers. It was the preliminary examination transcript where the defendant, who had never been provided a copy of the exam transcript, thought something exculpatory was contained within it. And the defense lawyer, and I get it that he was not the first lawyer to represent him, but I mean, still, you want to make sure that if you're spending time with your client preparing for trial, that he's got the information necessary. If he's got points to make, you'd be sitting there in the jail talking to him about those things. I don't believe, based on this record, anything like that happened, because he makes the admission that, I thought he had it, I didn't give it to him. More importantly, he didn't know what was in that preliminary examination transcript. And I laid out in the brief, I mean, and this is, you don't have to be the best lawyer in the world. You just have to be somebody who's diligent, who's actually getting themselves ready for a trial, to know what's in that preliminary examination transcript. And most importantly, and I've had this experience many times where I'm not lawyer number one who did the exam, I need to know what's in it cold. I mean, I start out cold, but I need to know it thoroughly, because I'm held to the same standard as any other lawyer when I come to actually try the case. I couldn't believe it when I read these things. And this man just did not get the effective assistance of counsel.
Great.
I have, but I'm happy to answer questions.
Anything else?
No, nothing further from me.
Thank you very
Further from you?
Thank you.
Have a good day.
You as well.
All
Your
right,
Honor.
take care.
Take care.
Case is submitted. Calling number 21 on our docket, case number 369-942, People versus Nico Shanta Simmons. Mr. Simon, another old timer.
Thank you. Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Simmons. This is a case where an alleged armed robbery out of Dearborn Heights went to trial 3 years later, and through no fault of Mr. Simmons, but perhaps maybe a little bit due to COVID and some other factors, he did not receive a speedy trial. And the fact is that he had a parole detainer. So after 3 years, finally getting the trial and ending up with a sentence of, well, extremely a lot of time. Because I know that he 10 to 30
Get it
plus
25,
10
yeah.
on the felony firearm. He received, I think, absolutely no, well, maybe 1 day credit of time served, which is amazing to me that after 3 years you get nothing for all the time you sat in jail. Now, I understand that there are the Barker factors to be considered, and he did make the claim of the lack of a speedy trial. There was a motion hearing. The motion was denied. And while there is really no specific thing that can be pointed to in terms of the loss of evidence or the loss of witnesses or the inability to present certain defenses, there is under the case Loud Hawk prejudice, which has been found in the anxiety of sitting there for 3 years waiting to be for a trial where you're facing life, where you're facing the public scrutiny. And I do believe that under these circumstances, there has been a showing of prejudice, and we respectfully submit that the motion should have been granted and that this case should now be dismissed. However, also at the time of the trial, there was another interesting issue, and that was the state trooper who told the jury that using a photograph from the MDOC.
He talked about Otis, didn't he? MDOC. How common? I mean, we know what it is. You know, I used it all the time when I was with the U.S. Attorney's Office. You use it all the time. We use it in the court all the time. How often does the general public go on to Otis? You know, how prejudicial is just say that when into an offender search? I mean, my family, they know nothing about it.
He was charged as a felon in possession, so it was a stipulation that he did have a specified felony. But I believe that bringing out a photo from the Department of Corrections is to me indicative of that maybe it was a more serious felony, that maybe it wasn't just a low severity case resulting in a term of probation. This was something more serious and perhaps something that the jury should give more consideration to, excessive weight. And don't forget, this is a state trooper, and I think the officers are held to a higher standard. They know the rules and they know the prejudice that can be caused by these kind of statements. And it wasn't in response to a direct question from the prosecutor. This was gratuitous. This was a deliberate attempt by this trooper to prejudice Mr.
Well, the exchange was they were asking about verifying identity, and the prosecutor asked, did you check the Secretary of State photo? And the officer said, yeah, Secretary of State and M.Dot Otis photo, right? And that was the exchange. Am I right?
That's correct, except that the Secretary of State doesn't run Otis. That's through the Michigan Department of Corrections.
Of course, right, yeah. The latter part of that response
Right.
was non-responsive and the problem.
And I think the general interpretation of a lay person on the jury, when they hear Department of Corrections, they don't think of probation. They don't think of minor incidents. They think of prison. They think of correctional facilities. They think of people doing hard time for serious offenses.
So a felon,
Yes.
right? But there was a stipulation that your client had a felony record, right?
Correct,
So
but not as to what that felony was. It could have been something minor, but I think that this impressed upon the jury that it wasn't just something minor, that it was something significant that generated this kind of documentation by the Department of Corrections.
So counsel, the trial judge gave a curative instruction and, jurors are presumed to have followed it. What do you have to say about that?
Well, I think that only reinforced the problem. As a matter of fact, a juror had a question about the instruction, and the judge again repeated this instruction, which I think just simply reinforced everything that the trooper said, which doubled, perhaps tripled the prejudice, because it kept telling him over and over again, this is a person who well, didn't say it's been to prison, didn't say it was a serious crime, didn't say what the crime was. And again, they knew that there was a stipulated prior felony, but they keep going over and over and over, literally 3 times, that this person has this felony, and this is why we have a photo, and this is how we knew who he was. This is how we were able to identify him. This is how we know who this person was. And the combined effect of the unsolicited, gratuitous remarks by the trooper when he was asked about a Secretary of State, and he goes into MDOC. And then there was some discussion, well, should we do something to cure the problem, or does that just simply reinforce it? Well, let's go ahead and give an
Do you
instruction.
use the words Department of Corrections or just MDOC?
He said MDOC,
MDOC Otis photo.
yes. And
That common knowledge of what MDOC Otis, going back to my original question.
well, it is to me.
It is to me too.
I can't say what effect, I mean, how much these jurors, but jurors are pretty
Going
sophisticated.
at prejudice.
I think the jurors know a lot more than they're supposed to. And I think that in this case, that was prejudicial to Mr. Simmons, and that it may have resulted in this verdict, and there should have been a mistrial. And I'm not saying that the mistrial was intentionally caused. It wasn't goaded into by the prosecutor. It wasn't even the question asked by the prosecutor. It would not bar, in my opinion, a retrial, but I think it should result in a retrial.
Anything else?
No, but I do have two
Case
more.
is submitted. Don't move. All right. Calling case number, that case is submitted. Calling number 22 on our docket, case number 371482, People versus Brent Dijon Nixon. Would counsel please identify themselves?
Good morning again, Your Honor. May it please the court, Jonathan Simon on behalf of Mr. Mixon. Mr. Mixon was convicted of second-degree murder. There was very little in the way of direct evidence. There was a Ring doorbell, I think, where the voice of the decedent was heard to say, "You shot me." But these were childhood friends. They've known each other all their lives.
Cooley High School classmates, Cooley Cardinals.
Oh, Cardinals. There was really no evidence other than, I think, the testimony of Mr. Mixon himself as to how things occurred. The decedent's girlfriend said, yeah, she's never seen any acrimonious behavior between the two of them. She's never seen any disputes, anything serious. And that was echoed by the decedent's mother. She too had known Mr. Mixon as a friend of her son for many, many years and never seen the two of them have any conflict of this nature. Mr. Mixon says, well, it was self-defense.
Didn't he tell his sister and her boyfriend that the decedent had disrespected him?
Yeah, but it seems as though it escalated from there, and he felt that he had to use deadly force to prevent what was
5 or 6 times. Right?
There were a number of shells, yes, and a number of shots fired, but again, that would go to not malice, but perhaps an overreaction, which, if not showing that the people have failed to prove self-defense beyond a reasonable doubt, it would at least should result in a finding that there was a voluntary manslaughter.
Did the defendant suffer any injuries or any cuts or anything as a result of the?
I don't believe so. No, but we do have evidence from Mr. Mixon's own testimony that he acted in self-defense. Then that and I don't believe that was disproven beyond a reasonable doubt. And I believe that based upon that, again, this court should either find that there was self-defense, that the case should be dismissed, vacated, or at least remanded for entry of a lesser included offense of voluntary manslaughter, because perhaps he overreacted to a situation which was precipitated by the decedent.
Well, counsel, I mean, just to that point, it seems like you are arguing, though, that there's insufficient evidence of voluntary manslaughter as well. So would we, to provide that relief, need to reject that argument too?
Yes.
Okay.
The other argument as to the length of the sentence, I'm not aware of any decision by this court since Posey, which is overturned within guideline sentence, but we do believe that it was unreasonable to sentence him to the very top of this guideline range. The guideline range was is 144 to 240, which is what, 12 to 20 years, and he got the absolute top of that guideline range of 20 years, 20 to 40-year sentence. And under these circumstances, we believe that it's unreasonable and an abuse of discretion to sentence Mr. Nixon to the very top of that guideline range.
No, nothing further from me.
Nothing further. Anything further for you?
Not on this case,
Don't
no.
move.
One more.
My case is submitted. Calling number 23 on our docket for today, case number 371333, People versus Christopher Tracy Kraft. And I believe Ms. Ruddy is back for another appearance.
And may it please the court, again, Jonathan Simon on behalf of Mr. Kraft. This was a case involving an allegation of incest. And we've alleged that the incest statute is unconstitutional because it imposes strict liability. The people believe otherwise. They say, no, it's a general intent crime. But whether it's strict, whether it's general, the fact is that it's unconstitutional, in my opinion, because it denies certain defenses which would or otherwise be allowed to be presented. The defense of consent is not available. Mr. Kraft's attorney attempted to endorse witnesses to present testimony pursuant to MCL 750.520J involving the complainant's prior sexual activity, and that too was denied because under the incest statute it is irrelevant. And so there was a lot of ways that there could have been a defense presented that could not be presented because of the nature of the proceeding. I mean, this is a case.
I mean, does a consent defense always need to be available for a criminal prohibition for it to be constitutional?
Well, I think that there's a constitutional right to present a defense, and consent
Well, right,
is a
but
defense.
present a defense, but not necessarily every conceivable defense, right? So I guess where's the constitutional requirement that for this offense, consent has to be available as a defense?
Well, I think that the Constitution allows any defense which would be relevant under the circumstances. And here the judge is saying, no, it's not relevant because consent is not a defense to a charge of incest. This could have been generally charged as third-degree CSC based upon force or coercion. It wasn't. It was specifically limited to the fact that Mr. Kraft was biologically related to the complainant. As a matter of fact, he didn't even really know for sure at the time. I mean, he'd always thought of her as his daughter, but until this case, there had never been any DNA, any documentation, any determination by any scientific method to show that there was in fact a biological relationship. And so I suppose mistake of fact could also be a defense, but these are things which you cannot bring to a case involving the charge of incest. And even if it is a general intent crime as opposed to a specific intent crime, it still, I think, unconstitutionally binds the defense to presenting just basically one defense. Did it happen or didn't it happen? And so if the defense says it didn't happen, well, that can be, a defense, but all these other mitigating or defenses, constitutionally recognized defenses of consent, defense of mistake, defense of lack of knowledge that as to the relationship, I think all of those were prevented, and those are all things that may have made a difference. And we respectfully submit that under the circumstances, the statute as it applies to Mr. Nixon, I'm sorry, not Mr. Nixon, Mr. Kraft, impermissibly denied him a right to present, a constitutional right to present a defense. We also believe that there were instances of prejudice which also made the trial unfair. And I say this all the time. Every time there is a sane evaluation, the sane nurse is always reads the report and says, well, she told me this, she told me that. And if it's not the very first time it's reported, it's hearsay. And if it's in the report, we believe it's still hearsay because the complainant was not there for medical treatment. She was there at the behest of, she was referred by the police. She's there to collect evidence for the prosecution and the police to collect evidence of CSC. And in fact, that's exactly what they did. They took DNA swabs, which served two purposes. One, to show the biological relationship between the parties, and two, to show that Mr. Kraft's DNA was present where perhaps it should not have been. And so reading this report and just going verbatim and saying, this is what she said this, she said that, she said the other, only vouches for the credibility of the complainant, only reinforces her testimony, only makes the case stronger based upon what is just cumulative evidence. And so I think that it's unfair, and I think that it should not have been presented. And that is more reason, I think, why this case should be reversed, why there should be a new trial granted. And this wasn't the only situation.
Counsel, can I just, I mean, can you just distill for me what the core theory of defense here was at trial?
I'm sorry, what?
Can you just distill for me what the core theory of defense here was at trial? Like identity, for instance, in this, what was not disputed, like that he was. So can you just tell me what was the core theory of defense?
It's difficult to say. He presents evidence that she was suggestively dancing and parading around naked in front of him. I think he was trying to show consent. I think he was trying to show that there, which of course was not a defense because of the nature of the statute. I think he was trying whatever he could to show that this is not a crime, which I
guess I'm trying to figure out, I mean, you know, I understand what you're saying about the testimony from the SANE and, you know, in particular, the identity and stuff. I'm also trying to figure out how that actually, you know, to the extent there is an error there, how it was actually prejudicial to the case presented to the jury.
Well, if there could have been a defense consent, and I think that's what he was trying to present in his testimony while dancing around without using that word. But then all the SANE nurse did was reinforce the complainant's testimony that it was force, it was coercion, it was not consent. It was something that was what could have simply been charged as CSC 3, force or coercion, which would have allowed him to have a fair trial, but it didn't. The third argument also, I think, points to the unfairness of the proceedings because another woman involved in Mr. Kraft's life was also presented. She was like an ersatz or surrogate mother to the complainant, not biologically related, but sort of raised her and knew her for quite some time. And while she was ostensibly presented to present additional testimony to confirm the complainant's accusations that this was a non-consensual act, she also seemed to go out of her way, much like the trooper in the Mixon case, by saying, well, she's asked the question, "Are you in a relationship with Mr. Kraft?" Her response, "Hell no." Why not? Well, because he's violent.
That's in response to the defense counsel's questioning, correct?
I think the prosecutor got into some of that too, but it does seem that that there was every effort to prejudice Mr. Kraft and that perhaps cause him to not receive the fair trial he's entitled to.
Okay. Gary,
Oh, no questions. Thank you.
Nothing further from me.
you have rebuttal time.
Yes, please.
Morning again, Your Honors. Rayanne Ruddy, Assistant Prosecuting Attorney, appearing on behalf of the people. I'm going to primarily rely on my brief again, but I would like to point out that I cite in my brief to People versus Davis, where the court long ago found that CSC third is a general intent crime. It's not strict liability. The intent of the defendant is, did he intend to have sexual intercourse? And the answer in here is correct. It wasn't accidental. It wasn't, it wasn't something that happened as a result of magic or something. But he had a general intent to penetrate his biological daughter, whom he also lived with.
And counsel, I guess to the next point, I suppose, is there case law squarely on point with respect to the unconstitutionality of not affording a consent or mistake of fact defense?
No, not that I have found. There were, however, many cases. I cited this court to People versus Piper, People versus Langworthy, People versus Brewer, People versus Corbett, where they do discuss that it's a general intent crime.
Right, yep.
Yeah, but I did not find anything that said that there was an issue with the constitutionality of that statute. And then moving on to the sane nurse situation, I understand defense counsel's argument, but this one falls squarely within medical treatment. It always does. It's this individual went within, I think it was 3 or 4 hours of having been sexually assaulted. This was not a situation where she went 7 years or
She
seven.
did identify the defendant.
And she did identify the
And that's
defendant.
not in furtherance.
It's not in furtherance, but it's important. Oh, that's a tricky one.
I'm not sure if it's outcome determinative.
Yeah, I don't think so, but it is, I think this sane nurse is also referring for psychological injuries and things of that nature, that could come into play. It is an interesting one. But if, this is a case that is different. This is a man she trusted, who's biologically related to her. And the fact that it was her father is going to cause more psychological trauma to her than an individual that was not someone she trusted and had just brought back into her life before that. But as to the final issue where Ms. Vanston was called to the stand, I analyzed it under a prosecutorial error manner because it seemed that I think defense counsel is arguing that she should never have been called at all. And I think that here she was called to rightly, she had information. She was one of the first people that the victim spoke to. She did corroborate the victim's testimony. And it was the defense counsel who had asked the question that she responded to with a statement that he was violent and a drinker. So, and that was not mentioned and in closings, it was not mentioned again by the prosecution. It was essentially ignored. And it did not cause an outcome and a change. I think that well, I'm not going to go that way, but it was proper testimony up until the point that she had done that. That was unsolicited. And it did not change the outcome of this case. I'm happy to take questions.
No, nothing further.
Thank you.
Thank you very much.
Thank you.
You're done for the day here, right?
Thank you.
Mr. Simon, rebuttal?
Yeah, very briefly, if the purpose of the sane nurse's testimony and her reiteration of this interview with the complainant is to go into issues of psychic trauma, I mean, I think that's even more reason to find its error. She was qualified as a forensic nurse examiner, not as a psychiatrist. So any testimony about the effects on the complainant, if any, I think would be beyond the scope of her expertise.
Okay, anything else?
Nope, nothing further.
Thank you very much.
Thank you.
Case is submitted. We're gonna take a 5-minute break.
All right. The Honorable Court of Appeals for the State of Michigan is now in session.
We're getting close to our 11 o'clock case call. We have 3 more cases left on our 10 o'clock case call, but for those of you that have come in for the 11 o'clock case call, I'll give the same admonition that I gave this morning. We've read everything. No reason to get up here and rehash a brief. We've read it. We're ready to go. So without further ado, we'll go to number 24 on our list of cases for our December case call, case number 370905, People versus Remy Anthony West. Okay, go ahead.
Good morning, Your Honor. May it please the court. My name is Cheyenne Scott, P number 88653, appearing on behalf of Remy West as a special assistant defender with the State Appellate Defender's Office. We are here today on one primary issue, specifically that Judge Lane in St. Clair County repeatedly interrupted Mr. West, which prevented him from having a reasonable and meaningful opportunity to speak and ultimately deprived him of his right to have a meaningful allocution during his sentencing hearing. These interruptions were not clarifying questions, contrary to the way that is presented in the prosecution's brief. They were 18 interruptions before she specifically said, now I'm prepared to sentence you. And these 18 interruptions ultimately derailed the purpose of prosecution of allocution and transferred it from a chance to be a chance for the defendant to speak on his own behalf, and it changed it to a lecture and not what the purpose of allocution is for. Ms. Judge Lane in her specific interruptions were ultimately casting doubt on Mr. West's statements, providing that he was not sincere and that she didn't believe that he was actually meaning what he was doing when he was trying to take accountability. And she essentially acted as a cross-examiner of his allocution. And this is clear from the way that specifically when Judge Lane inquires as to why Mr. West absconded from sentencing, that no matter how he answered, it wouldn't have mattered to Judge Lane. When he did answer to her question about why he absconded, Judge Lane immediately provided 2 alternatives on how to take responsibility for his actions, and how those answers would have been sufficient for her and that she would have wanted to hear. So it never would have mattered how Mr. West would have responded initially.
So counsel, let me, the really legally interesting question for me here is prejudice.
Mhm.
And I'm curious to get a better idea of your take on how we think about that here. So let's say I agree with you. Okay, that right from elocution was violated.
Mhm.
How should we look at the question of prejudice for this sort of issue?
So obviously the question of prejudice comes from Koreans that plain error needs to be established if it's unpreserved. And we acknowledge that this was not preserved at the trial level. However, specifically in People versus Petty, the Supreme Court recognized that when the right of allocution has been denied, that it automatically entitles a defendant to a resentencing. So we would request that it ultimately.
So is this a structural error? Is that or tell me if it's not, tell me how your argument's different than that.
We would argue that it is a structural error, and I think it's the line of cases under Davis that establishes what like a structural error is. I know that wasn't mentioned in our brief, but I have, and I would be willing to find the case for you, and we would supplement it. But that discusses like what creates a structural error, and it's because it's been acknowledged in People versus Petty that the right of allocution is so integrated into the sentencing hearing and is so important, especially as one of the only times that the defendant may be able to speak at a hearing, that it needs to be expressed that they reserve this right. And so, and also just the automatic right of remanding down for a resentencing. It was acknowledged in a recent case that this court, and we filed a supplement or an appendix to People versus Killian. The court at the end of that automatically says at the end that when the right of allocution has been deprived, even when they've received a partial allocution, that they need to be able to go right down, that they're entitled to a resentencing as a result of People v. Petty. So inconsistency with People versus Killian, if I didn't say that before, I'm sorry. But so in line with
Killian
People,
is unpublished.
it is unpublished, yes.
Right. And I understand I understand you laid out well in your brief how this,
Right.
but this particular trial court has had issues with this.
Correct.
But
And
this
that's
is in that string of unpublished authority.
correct. And it's one of those things where in the same line of things, Judge Lane, who is actually the same judge in Killian, did this very similar things. In Killian, she referred that the defendant there was a manipulator. Here, Judge Lane specifically referred to to Remy West as being a manipulator because he submitted character reference letters, and according to her that he was manipulating these character references just because they submitted letters and she knows him as one way. She knows him from a matter of maybe 3 to 4 hearings. This was a plea case. It wasn't a trial case. There was no evidence submitted where anybody could speak on his behalf in front or anybody could speak against him. He took plea, he took responsibility. And then when it comes time for him to say and request the court to have mercy on him because he really wants to change his life and has started to change that, she starts to challenge his statements and effectively intimidate him, just like the judge had done in Dixon Bay. And particularly getting back to Dixon Bay, which establishes like the right of allocution the most recently, is just I really want to point out that Dixon Bay kind of created for allocution and sentencing 2 distinct parts of sentencing hearing. Allocution is its own thing and sentencing is its own thing. So then the court in Dixon Bay has specifically said that allocution is a time for the defendant to speak on their behalf. The court, if they want to lecture, if they want to or admonish, if they want to cause question to what the defendant said, that's during the sentencing portion. And specifically, Judge Lane in this case, she had gone through she gave Mr. West an opportunity to speak, and then she continued questioning him and berating him and lecturing him on, well, I don't believe you, and why didn't you do this thing better? And then, and he's trying to apologize, and she's cutting him off, even after he did say a couple comments of remorse. And then she moves into the sentencing portion by her statement of, now I'm prepared to sentence you.
Do we know what more he wanted to say?
We don't necessarily know what.
Does it matter analytically, or tell me about that.
I think it could. We would want to know more what he wanted to say. It could have mattered. Like the point of allocution is to try to encourage the judge to reduce your sentence. If he had been able to say his piece, or at least if Judge Lane had clarified if he was done at the last when he did finish, maybe we would know that he was done and that there was nothing further to say. But it's also important to note that your typical defendant, when you're in front of a judge at probably the most terrifying day of your life, that you're already intimidated because you're in front of a judge. You're a lay person, you're not an attorney. And so you don't have the comfort of being at this podium and standing and trying to talk to a judge. And then on top of it, you're being interrupted and you're being called names, and you're and based off of someone who knows only a small snippet of your life. So I think for analytical purposes, it is important that we do need to know whether or not he was done. And if she wanted to say those things that she did say, it needed to wait until she said, now I'm prepared to sentence you, because it is important that there is a distinct part of the sentencing hearing, that there is an allocution.
He was the
that there's a
third
sentencing.
habitual offender, wasn't he?
He ended up pleading to that. He was actually.
He's had experience in the criminal justice system. This wasn't its first time.
Correct.
Right.
But it also doesn't change the fact that those felonies weren't
It wasn't
necessarily.
a deer in the headlights, I think,
I think that's fair. I also don't think that it completely diminishes the right to allocution that you
I
are.
agree with you.
Yes.
Yeah, but I don't think he was as,
Right. The other thing is.
unsophisticated as you might want to
Correct.
portray he was.
Correct. And I think that's fair. But it's also important that this is as Judge Mariani specifically said, this isn't a one-time thing with Judge Lynn specifically. There's
No,
multiple.
there's another one, and then she's been up here at 2 more, and she was affirmed on the other 2 that you cite in your brief.
True. There have been some where, especially I think you're referring like maybe to Spencer, where it was found that it was like harmless. I think those are the cases where she's been affirmed. It's also been.
Alton Spencer, I think.
Yeah,
you
so-
cite both of them. She was affirmed on both.
Correct. And specifically to Spencer, I think you can distinguish the case. Spencer.
Cited 3, you cited Killian, which we talked
Yes.
about. Okay.
Yes.
You cited Alton Spencer.
Yes.
Okay.
And I would like to distinguish Spencer specifically. Spencer, where she was affirmed, it was affirmed on the fact that those were clarifying questions. It is our position that the questions she was asking, while they initially may have been clarifying as presented by the prosecution, there's a very clear point where it changes from clarifying to lecturing. And in People versus Bailey, it was found that like the point of allocution is not for a lecture. That is a sentencing portion of the sentencing hearing. So the judge, if she had concerns or she wanted to express these admonishes, she should have done it during allocution. And it's cleared in the transcript that it transfers from a clarifying questions to lecturing. Specifically, like I'd look at page 27. So right in towards the beginning of it, she asks them, why did you run from the police? He answers, and she says, if you're going to take responsibility for your actions, the defendant says, yes, ma'am. And you know the police are there to take you into custody. First of all, why'd you run to begin with when you just got more convictions? And secondly, when you know they were there to take you into custody, you didn't
You
show up
cited
for
all this in your brief.
Yes, Your Honor.
Okay, so.
So yeah, so just overall, I think that it is and there's a distinct point of sentencing. There it changes from lecturing, and that's not the point of allocution. He's interrupted and he's deprived of his point. And in the nature of People versus Petty, we would request that you are given that it is remanded for a full resentencing. And that because he was denied his right of allocution to to a meaningful allocution. And we would request that he's just given a full resentencing, that's clear for the judge, and perhaps before a new judge, because Judge Lane, with her comments that she expressed, those were strong opinions that even a common layperson would not be able to put aside. So that, unless there's any further questions.
Thank you.
Nothing further.
Thank you very much, everybody.
Thank you.
Thank you. Good morning, Your Honors. Josh Sparling on behalf of the people of the St. Clair County Prosecutor's Office. Some of those cases that were just cited, I don't know if that's a good thing or a bad thing, that I think I was the prosecutor on those other 3 cases as well with St. Clair County. So I have a familiarity with Judge Lane. Just a couple of things that I want you folks to consider before making your ruling. One, I don't think it is necessarily appropriate for this hearing to say we have to put Judge Lane in her place. I think we should look at the merits of this case solely on this case. As far as this case,
I mean, counsel, we do have we're getting a steady stream of these.
I completely understand that, Judge. I just asked that we look at this one, and I, as being in the courtroom, I have seen the probing mind and the probing questions while somebody's making a statement. I kind of find it akin as to the oral arguments that we're making here today. Whereas if there's something that pops in your head that you want clarification on.
But I mean, we're clearly not in the same posture of an allocution in a sentencing.
I agree.
So it seems like there's a material distinction there that needs to be recognized.
I agree with you. And I'm just saying, for that purpose, I'm not saying it's the same. I'm saying that it's the way I believe, from looking at the context of the conversation, that she was trying to clarify issues or points that the defendant was making at time of sentencing. Do I think it's the best approach? Not necessarily all the time. I think she did remedy. The real question here is, did plain error did plain error occur where prejudice attached? And I go back to the point where she said, would you like anything else to say? And at that point, he gave full allocution. He stopped. And then there was this berating. I agree. There was this kind of berating, or I think you did this kind of argument that came from the bench, but that was her restarting up the questioning. She didn't have to do that at that point. She did give the defendant a full opportunity to allocute. She interrupted him at the first time. And then after they went the back and forth, she said, do you have anything else to say? And he then did another full one. She then restarted up the conversation with him. At that point, she could have jumped in and said, I'm ready to sentence now. It was her asking for those clarifying questions after he was done allocuting that I think that we really have here. So that's just what I'd like the court to consider. Unless you have any other questions for me.
I'm just going to make a point that after what you're calling his ability to allocute, I don't think she was asking any clarifying questions based on my review of the record. It was more berating, more, stating her position on how she feels about the case. She didn't ask him any questions.
Yeah.
From my review of the record at that point.
You're talking about the second one,
Yes.
Judge? Yeah, and I think that's a fair point to make. And I think you would agree that after that second allocution that she let him finish, if you want to call it, she launched into berating. She could have said, I'm ready to sentence then, and just started without this further back and forth colloquy that she had. But I think at that point, regardless of her methods, she did give him that right to allocute, and I don't think prejudice attached.
Are we talking about when she said, well, it's very easy to say those things?
I'm sorry, Judge.
Are we talking about when the Judge Lane said, well, it's very easy to say those things after you allocated? You went for quite a bit of time.
Yeah, Judge, I have the, I was talking about where she came back at the end and said, do you have anything else to say? And then there was about a paragraph there.
Okay.
It was on page 28 of the transcript where she says, what else would you like to? So they kind of argued for, not argued, I think that's an improper term for me to use, but they went back and forth for a little bit. And then after the first attempted allocution, and then on page 28, she said, what else would you like to say? He went with everything there, and he kind of finished with, I mean, he didn't say, I'm afraid to say anything here. He actually launched into a full allocution and ended up saying, I'll be taking full advantage of and coming out a bigger and better man, and stopped there. And then she launched into, yes, right to your point. Well, it's very easy to say those things. So I think he was finished at that point, and then she kind of reinitiated the conversation once again.
Okay.
Thank you.
Thank you. Dave?
No, I'm all set. Thank you.
Thank you.
Big rebuttal?
I just want to point to the point that was made by Judge Robinson Garrett. After Mr. West did have the opportunity to make his to have a brief allocution, she said it's very easy to say those things. And just because there's a period in the transcript, we don't necessarily know that he was done.
Well, he
After
did respond, I truly mean them. I truly mean them.
And he was also completely interrupted during those additional statements. If you continue to go through those, she's just completely dismissing everything he's saying, and she's still opening it up for him to have his say in his speech. But she's completely dismissing everything he's done. So it's ineffective for everything he's saying when it's supposed to be a point for him to have his effective
I
allocution.
understand what you're saying.
Yes. So, and then also just one point, when it comes to resentencing and kind of in nature that this is a repeated issue with Judge Lane. It's important to note that when you can remand under Careens, that Careens also notes that remand is appropriate to preserve the appearance of justice. It has been noted by this court and the state that it is a common law right to have allocution, and when you don't have that allocution, that it's a problem. And so the more times that you are deprived of your right of allocution, it really affects the way that justice is perceived by the general public. And so I think that is also a really important point to make. So at this point, we would just request that unless there's any questions.
No, nothing further.
Nothing
Thank
further.
you.
Thank you.
Thanks, Council.
Well argued. Is this your first time up here?
Yes, I
Thank
got
you.
my P number a month ago, so.
Oh,
What's that?
I got my P number a month ago, so.
Oh, my goodness. Congratulations.
Oh, did a great job, both of you.
Thank you.
Hopefully it wasn't too hard on you.
No,
All
thank you.
right. Well, good luck.
Thank you.
See you again. Where'd you go to law school?
Wayne State.
Yes.
Case is submitted. Calling number 25 on our docket, case number 367648, People versus Jonathan Belton.
Good morning, Your Honors.
Good morning.
My name is Hannah Barron. I represent Mr. Belton, and Mr. Belton's family is here in court today in the gallery as well. So my brief focused on many arguments. I am going to focus on what I think are the two most important arguments in the brief today. First is that the trial court at the resentencing affirmatively misunderstood Boykin's mandate that the court had to consider Mr. Belton's youth as mitigating in fashioning his term of year sentence. And Boykin is very clear that consideration of youth as mitigating continues through the term of years portion of the sentencing. It doesn't stop after the decision of life without parole or a term of years is finished. And the record here shows that the court did misunderstand that mandate. It's evident throughout the record in numerous ways. The first is that there's really no substantive discussion about Mr. Belton's youth as mitigating at the resentencing hearing.
But Counsel Boykin doesn't require record making on this point, correct? It's very clear about that.
Of course, Boykin is clear about the fact that record making is not necessary, but it is evident in numerous other ways that the court misunderstood how it needed to make that consideration. So what the court did say at the resentencing was very briefly, the court said, the entire reason we're here is because of Mr. Belton's youth. That is the reason for the resentencing. Now, this showed that the court was only considering that Mr. Belton's youth was the reason that we were there for the resentencing, was the reason for the Miller hearing, not an understanding that the court needed to actually consider youth as mitigating. And while Boykin is what my brief relies upon, that's precedential case law for this court, the court's ruling in Abitoy, which is unpublished, is very illustrative of a very similar misapplication of Boykin and its principles. And in Abitoy, the court said something very similar at the resentencing, said...
Abitoy bounced back and forth a fair bit, didn't it?
It was
seemed like
returned.
it seemed like the court was having a tough time understanding that youth isn't just kind of an isolated thing that you then weigh against other things. It's just that it embeds with the other factors, other considerations you need to think about youth in general, right? Because it's pervasive.
Yes,
So where in this case do we show that the court wasn't thinking about how youth impacted the circumstances of the offense and the offender? I mean, that's ultimately what the mandate is, right? You have to make sure you're thinking about youth when you're thinking about proportionality of offense and offender. So where do we see that is not happening when you look at the trajectory of the resentencing overall?
Well, at the resentencing, at the final resentencing hearing, the court did say, I believe I've already made it clear that I have considered Mr. Belton's youth. And that directs us back to the court's order that preceded the resentencing hearing, where the court went through the Miller factors. The court did go through the Miller factors, but showed a misunderstanding of what those Miller factors were supposed to do. And that was shown in multiple ways. Most importantly, as to how youth was not properly considered finally at the resentencing hearing, the court stated while going through the Miller factors that Mr. Belton's youth did not weigh one way or the other in terms of its mitigation. So at the resentencing hearing, the court is saying that it's already considered Mr. Belton's youth, but what we see previously is that the court did not consider Mr. Belton's youth as mitigating. Also, in that same order, the court, in going through the Miller factors, actually found that one of the Miller factors weighed heavily in favor of a sentence of life without parole. Now, while of course the court is permitted to go through aggravating and mitigating circumstances during that time, the Miller factors case law is very clear. Taylor and Skinner make very clear that the Miller factors are mitigating or neutral at best. The Miller factors cannot be...
Youth is mitigating. Or potentially mitigating. The Miller factors are things that you're supposed to think about when you're thinking about youth. So I don't think it's necessarily the case that the circumstances, because I think what you're talking about is the court recognized that the circumstances of this offense, the court found weigh fairly heavily in favor of a life without parole. And found that they didn't, when looking at those circumstances, they did not reflect what the court viewed as, an influence of youth based on those circumstances. Now, it found that youth, factored in, mitigated in other ways. But when it came to the circumstances of the offense in particular, the court didn't seem to find that there was a reason for mitigation of that consideration stemming from your client's youth.
Well, I'm trying to parse through the different pieces of that. First, I would assert, and I'll try to get a cite for this court, I'm not sure I have it at the ready, that Skinner and Taylor actually do explicitly state that all of the Miller factors are mitigating or neutral at best. Again, the court is of course permitted to think about the aggravating circumstances and talk about the aggravating circumstances in making a decision about whether to impose a life without parole sentence, of course. But the Miller factors themselves are mitigating or neutral at best.
I guess, are you saying that the circumstances of the offense are a Miller factor?
I'm sorry, can you say?
Are you saying that the circumstances of the offense are a Miller factor? That seems to be what I'm hearing but by that logic, then the circumstances of the offense are always or always mitigating? Is that your position? Okay,
That
so
is
help
not
me
my
better
position.
understand your position.
So the Miller factors, one of which is the circumstances of the offense, are all mitigating or neutral at best. And the reason for that, because of course, sometimes the circumstances of the offense can be aggravating, of course. But the reason that as framed by the Miller factors, the circumstances of the offense are mitigating or neutral at best, it's asking the court to make considerations such as whether this was an aiding or abetting situation where the defendant's youth was made them particularly susceptible to peer pressure, made them particularly susceptible to the situation that they were in. I think it's fair to assume that the court wouldn't have found it mitigating regardless, that circumstance mitigating. I think it's fair to assume that the court would never have found that that factor mitigating in Mr. Belton's case. However, that factor should have been found to be neutral, again, at worst. That's what the Miller factors are. The court still could get into a discussion of the different aggravated circumstances. And I will try to pull a cite for that and
No, I
maybe
think,
in my
I think
rebuttal.
we
Yeah.
understand.
Okay. But I do think what that really illustrates is because of course we're not we aren't contesting where the court ended up on that question of life without parole. The court did not give Mr. Belton a life without parole sentence, and we are in no way objecting to that. However, I think that order was illustrative of the failure in the court's understanding, the failure of the court to understand the different jurisprudence that we've had in terms of considering youth as mitigating. And again, I think really the most critical one I'll just go back to is that the court at the resentencing hearing essentially told all of the parties that it had already done all of its thinking about youth, that had already preceded its decision on the term of years. I've already considered Mr. Belton's youth. That's why we're here, Mr. Belton's youth. Those are the only discussions of youth at the resentencing hearing. And again, looking back at that order, in that order, the court stated that Mr. Belton's youth was neutral. So there's really nothing on this record to indicate that the court considered Mr. Belton's youth as mitigating in fashioning that term of year sentence.
It sounded, as I read the record, that the court did the Miller, it's about 4 days, right, of a Miller hearing, and came out of that thinking that, that the prosecutor's request for life without the possibility of parole may be appropriate. I think is what the court concluded. It may be. And they came back for the final day of resentencing. The court said, I've gone back and forth about this. I think that sentence has been, I think the court said it has been earned, but I'm not going to impose it. I'm going to go for a term of years. And the term of years was ultimately obviously at the top end of what was statutorily permitted. So I guess it seems like when you're taking that consideration in, in total, it does seem like there was, a consideration of your client's youth and in terms of the spectrum of available punishments, which obviously are very severe, right? And there's no dispute about that. But for this offense, life without the possibility of parole was an available punishment. And it sounds like, as I read the transcript, the court felt that very severe punishment may be warranted, but out of consideration of the youth of your client at the time, that it was not going to impose that most severe punishment, but instead a term of years, which I understand you argue is also obviously and is a very severe punishment.
Yes.
So I see the mitigation, I suppose, from the life without parole punishment, which, as I said, is very severe, but nonetheless, it's still been left open to a term of years.
Well, with all due respect, I do think that is a big assumption. That would mean that there is no way for defendants to really contest their term of year sentence, juvenile defendants who've been given a term of year sentence that seems disproportionate, where the court declined to impose a life without parole sentence and found that life without parole sentence disproportionate.
Well, the court didn't, though. I guess that's part of my point. Is the court didn't find it necessarily disproportionate. The court said it may be appropriate, and then exercised its discretion not to impose it because of your client's youth and because she wanted to leave open at least some possibility of parole, albeit a very distant one.
Well, the court found that is correct, that the court did state it may be appropriate, but ultimately the court found that it wasn't appropriate. That is what the court decided, that a life without parole sentence was not appropriate. And yeah, and so I do think that the same rationale applies, that I don't think that it would be this court's position that because a life without parole sentence hasn't been imposed, a juvenile defendant cannot find their sentence disproportionate. I don't think that that's what the case law shows. And what Boykin states is that there is a continuing mandate to consider youth as mitigating in fashioning the term of year sentence. So that doesn't stop. That inquiry needs to be done in figuring out what the term of year sentence should be. And again, it does seem like the court here thought that inquiry could stop in deciding between life without parole and a term of year sentence.
So I'm just curious, how long has the client been incarcerated now?
You know, I do not know off the top of my head, which I should.
Well, the offense was in 2008, correct?
Yes. So what would the quick math on that be?
17 years.
Thank you. 17 years.
So he was, I know the offense was in 2008, but he was sentenced into the trial. I don't know how long it took for the trial and the sentence, so.
He was sentenced about 2 years later, but he was in custody that whole time. So he has been in custody throughout. Yes. I believe he was actually in solitary confinement because of his youth in jail for those 2 years.
Okay.
And so I will move on to the second point that I'd like to make, which is that Mr. Belton's sentence is a de facto life sentence.
How old will he be if you were to do the max here?
He will
40
be
to 70 year sentence?
just over 58 years old. And his life expectancy as, well, I don't know his exact life expectancy, but similarly situated person's life expectancy, according to the statistics that I cited in my brief, would be about 50 years. And that's for Michigan prisoners who have been sentenced as juveniles. And that's for numerous different reasons. That's because prison decreases people's life expectancy as much as 2 years for every year that they're in prison. Mr. Belton, and this is actually not even contemplated in the statistic of the 50-year life expectancy, but Mr. Belton's race also does appear to reduce his life expectancy. He is African-American, and so his life expectancy may even be lower than what is cited in my brief. So his sentence does exceed his life expectancy by about 8 years, if not more. And what Miller, what Graham, what Montgomery all say is that a youth who has not been found to be the most irreparably corrupt youth, they're meant to have a meaningful opportunity for release. Mr. Belton doesn't have a meaningful opportunity for release. And while Judge Mariani, I hear your comments about that the court did consider life without parole, that the court did say that life without parole may be appropriate. Again, what is important here is the court ultimately determined that life without parole was not appropriate. The court ultimately determined that Mr. Belton wasn't one of those irreparably corrupt youths that this rare sentence should apply to.
So I guess are you making a argument that the statute is unconstitutional in terms of the permissible range? I mean, because it sounds like what I'm hearing from you is that if the court ultimately decides for whatever reason that it's not going to impose life without the possibility of parole, and then does a term of years, I mean, it's always I guess based on the life expectancy numbers you provide, it sounds like that 25 to 40 range, at least to some extent, will always be unconstitutional.
That may be the case. I mean, I think maybe we would all hope that prisons wouldn't reduce person's life expectancy so drastically forever, maybe. But that is where things stand right now. That is the life expectancy for people in Michigan prisons, specifically juveniles who've been sentenced at that age. So yes, maybe as applied currently, that portion would be unconstitutional.
Across the board, facially. Or are you?
Right now, we're as life expectancy is right now. Yes. Yes.
Got it.
And if there are any more questions.
No, nothing further from me.
You have rebuttal time.
Thank you.
Good morning, Your Honors. Matt Fillmore from the Oakland County Prosecutor's Office on behalf of the people. In regard to the first issue, the articulation of youth, as you know, Boykin says that the court must consider youth as a mitigating factor when sentencing a juvenile. But I just wanted to quote Boykin that said that trial court, in quotes, need not articulate their basis for considering an offender's youth during sentencing hearings conducted under MCL 769.25, in which the offender is sentenced to a term of years. That's this case. And then just last year in Copeland, this court went on to say that the court need not consider on the record defendant's youth as it applies or as it fits into the snow factors. So there's no.
But they do have to consider it.
Consider the youth, yes.
Yeah, right.
Yes.
So, and I mean,
I'm
we've
sorry.
been,
Articulate, was it?
articulate, right? I mean, and we're in a little bit of a tough spot with this precedent because we have a requirement to review, whether the court has considered something that it doesn't have to tell us it considered. So we have to do our best. But to opposing counsel's point, how do we know that this was actually properly considered here, given that the sentences that were on the table, what ended up being handed down?
Well, the trial court made two pertinent rulings. The first ruling was a written opinion on whether it was deciding whether to impose life without parole or a term of years. In that written opinion, it goes through the Miller factors. It talks about the first Miller factor, which requires the consideration of youth. In that written opinion, the court said defendant was immature and his brain likely had not reached its full development. So that's an indication that it considered youth as a mitigating factor. The court also said the court is mindful of the lack of maturity at the time of offense, which explains some of defendant's behavior surrounding the murder. That's another indication that considered youth as a mitigating factor. And then at the sentencing hearing, after the court decided to impose a term of years, the court said, and I'm going to quote, "And so I'm going to sentence Mr. Belton to a term of years. It's in consideration of his youth, and I'll wait to sentence him until I hear arguments from both sides." That's an indication to me that the court considered the defendant's youth and decided, no, I'm not going to impose a life without parole sentence. Because of his youth, I'm going to impose a term of years sentence.
Or then the court had to choose a sentence.
Correct.
Okay, so how do we know how the court chose its sentence here?
I mean, the court did go through, made an articulation of why it imposed a sentence. The court did mention the defendant's youth, said, and the entire reason we're here is because of Mr. Belton's youth. So the court knows youth is one of the main factors that it had to consider when it imposed a sentence. The court said, I think I've already indicated that I've considered defendant's youth. And at the very end of handing down the sentence to a term of years, the court said, in consideration of the fact of his youth and the impulsiveness of his actions, the court feels this is a proportionate sentence. So multiple times the court talked about considering defendant's youth. And as it said, it went back and forth between life without parole and term of years. So it was, I mean.
To, opposing counsel's point, what we have here is a 40-year minimum, right?
Right.
So no possibility of parole until then, with a court that's declined to impose life without the possibility of parole. I think counsel's point is that how is this really different, all things considered, given what your life expectancy is in jail? So how do we how do we know what the court was thinking here on the one hand in not imposing life without the possibility of parole and declining to impose that, but then imposing this term of years that, by some measures might be effectively the same.
Well, the court stated that it was very close to imposing life without parole. It had gone back and forth several times, and it decided ultimately that the prosecution had proven that it had met its burden of showing a life without parole sentence was proportionate, but the court imposed a term of years. So instead of the life without parole, it imposed the top of the
Yes, right.
statutory range. So that
Understood, but I mean, I think your opposing counsel's point is that those aren't really different based on the realities of incarceration.
I think there's a substantial difference.
Right, so tell me how.
Okay. Well, I want to go to the Eads opinion that this court issued a few years back. And in that opinion, this court said that the life expectancy of a prisoner is 64 years.
An adult prisoner.
An
That
adult.
was someone who was first incarcerated as an adult,
Yeah, it said that.
which is not this individual.
Correct. The court didn't say what the life expectancy would be of a juvenile who was sentenced to life without parole. And there haven't been any opinions that talk specifically about that. So defendant cites an ACLU report that says the life expectancy of a juvenile sentenced to life without parole is 50.8 years. Well, first of all, the defendant was not sentenced to life without parole, so that's not completely accurate to our case or pertinent. But the Eads talks about 64 years. Defendant is he'll be released at the age of 58 at the earliest.
First possibility.
Correct. So
How old is he now?
he is, I believe, 32. He's been in prison for, I think it's 17 years. So, well, the legislature determined that these sentences, juveniles sentenced for first-degree murder, that the minimum sentence should be between 25 and 40 years. So the legislature was obviously aware that these juveniles who are getting sentenced are, at the time, were between the ages of 17 and younger. And so it knew that that was a possibility to impose a sentence of 40 years on someone who was 17 or almost 18 years old, which would be, serving 50, 57, 58 years old. And it determined that was appropriate.
Right, and I mean, I think our job is to then evaluate that legislative judgment for constitutionality.
Right.
So I understand this is what the legislature decided with respect to this class of offenders and offenses, but it's a separate inquiry then of, is that a constitutional judgment? Does our constitution prohibit any part of that? So why doesn't it?
In the People v. Pirtle case, which it talks about how a defendant's age when they're eligible for parole.
That was an adult offender.
Correct.
So it's outside the scope of Miller.
Correct.
So I have difficulty. I understand. I know I'm familiar with Pirtle. I understand the point that's been made in the context of adult offenders and their life expectancies. But it seems like you're in a different space when we're dealing with juvenile offenders now, given the mandates of Miller and its progeny. So I'm not sure if Pirtle gets us very far in terms of understanding why this sentence is constitutional.
Okay. I mean, I think Pirtle talks about how I think this can apply to adults and juveniles when you're talking about whether a person's age when they're going to be released is a factor that makes a sentence proportional or not. And like in Pirtle, and I realized that was an adult, but he was sentenced to 56 to 80 years. And his earliest release date was when he was 89 years old. And they found that was okay. The court found that was okay. And I think that the same idea can apply to both juveniles and adults. That I don't think an adult, just because they're released, eligible for release at 89, doesn't mean a juvenile can. I mean, in our case is way below that, but I think the same idea can apply there. I did cite two unpublished opinions in my brief that the same issue was raised, the de facto life sentence, and those apply to juveniles. And the courts rejected both arguments. So there is, although unpublished, there is precedent for, in this court, for rejecting that argument. And yeah, it's, if the court has any other questions, I would be trying to answer those questions.
None further from me.
Have I answered your questions adequately?
I think I understand your position.
Okay.
So yeah, between this and the briefing. Yeah, thank you.
Okay.
Any unpublished cases that you're talking about, Martin and Lawnsbury?
They're in my brief. I can't remember the names of the cases, but there are two of them, and I attached them in my brief.
All right, thank you.
Thank you.
So just briefly as to the first argument about Boykin, I think that there's a lot of focus on the very brief line in the resentencing that the court was considering the defendant's youth. And I think that that's left us with having to make a lot of assumptions about what that means, that's all the court said in giving its resentencing, that the court was considering the defendant's youth. We shouldn't need to make that many assumptions about what the court was thinking. And it is accurate that the court does not need to articulate its bases line by line. Again, Boykin made that very clear that that's not necessary. But in this case, we're left with a record that really does not show that there was any analysis as to how.
What would have been a sufficient explanation to facilitate our review?
Well, what I think would, and I do think that there's a helpful discussion of that in Abatoy, again, which is just persuasive, not precedential, but I do think there's a helpful discussion in there about what it looks like to properly apply Boykin and what it looks like not to properly apply Boykin. While the court wouldn't need to line by line go through each of the snow factors, say this is how youth looks in terms of deterrence, this is how youth looks in terms of rehabilitation. I don't think it would be asking too much for the court to talk about those concepts and to talk about how it's considering youth. Well, there's nothing specific that would be necessary in terms of talking about each of the snow factors. And while the court does not need to, again, make a line-by-line analysis of the snow factors of youth as it pertains to each snow factor, it does need to facilitate meaningful appellate review. And here, what I hope I've made clear is that the issue is not just that the record is bare and that the court needs to better articulate itself. But here, what we're left with is something that really doesn't show us meaningfully that the court was considering youth the way it was supposed to in fashioning the term of year sentence. And then, and if there's any more questions on it, yeah.
So let me just be clear. What are you asking for in relief?
We're asking for a remand for resentencing. And then in terms of the Eads argument, in terms of the argument that this is a de facto life sentence, just very briefly, Hurdle shouldn't apply in this context. The case law about adult defenders shouldn't apply in this context. Our case law has made it very clear through all of the jurisprudence that youths are constitutionally different in terms of sentencing. So that simply should not, the holding from that case should not apply here. And in Eads specifically, the court did consider life expectancy. That was part of the discussion in Eads. So what the case law is showing is that that consideration is certainly different in terms of juveniles.
I have no further questions.
Nothing further from me.
Thank you
Thank
very
you for the
much.
argument.
The case
Thank you.
is submitted.
Thank you both.
We're still on our 10 o'clock case call, the last case from our 10 o'clock case
Wow.
call.
No, I'm okay.
Number 26 on our docket for today, case number 371233, People versus Malcolm Xavier Watson.
Good. Is it good afternoon now?
It
Good
is.
Afternoon, Your Honors. Susan Walsh on behalf of Defendant Malcolm Watson. It's a pretty straightforward case. I used to work in pre-hearing really long time ago. And so I understand how much work has gone into the case already. I would just like to address one of the arguments by the prosecutor about my brief, like waiving the first issue. And I went back and I looked at it and it wasn't my best work, but I really do think that, that the issue was there and that it was briefed. Sometimes after all these years, I just make assumptions that everybody knows what I'm talking about. But I did note the parts of the transcript that I was relying on and cite those in my issue, and that by I guess the weakness in the prosecution's case was that none of the co-defendants testified at the trial. It was all police officers testifying. So I felt that the prosecutor improperly injected things into the trial to make up for the fact that they didn't have one of the co-defendants there. And so the question, oh, how did you know the defendant, asking police officer that, and then saying, just making the legal conclusion that Mr. Watson was a lookout. And then towards the end of that issue, I did an analysis on how that was outcome determinative. And so I think that the issue is preserved, and that the prosecutor improperly made comments that weren't limited to the facts and evidence, and were outside the scope of the testimony. So I think that that is set out in that issue, and that would justify a finding that a new trial is required for prosecutorial misconduct. And so unless the court has any other questions, I think that the issues are laid out in the brief adequately.
No, none for me.
Thank you.
Very much.
Thank you.
You have a lot of time for rebuttal.
Good morning, Your Honors. May it please the court, Joseph Shade on behalf of the people. To cut to the chase, I don't have anything new to add that's not in the briefing. So I will rest on my brief, but I'm happy to answer any questions that the court may have.
No, none for me either.
We'll rest too.
Okay.
Thank you, Your Honors.
Go ahead, Ms. Walsh. You have a lot of rebuttal, I would imagine.
Do you have any other questions for me?
No.
Okay. Yeah,
Nothing came up
Ron,
between you.
wind it up. Yeah. All right.
Thank you.
All right, have a good day. Thank you very much. You saved us. Okay, that case is submitted. This next case may take a little bit of time. Let's take a 5-minute recess.
What we have before you, and I know you've read the briefs, and I know we've talked a lot about different issues, but what we have before you today is not a challenge to the tax foreclosure statute, and it is not a challenge to the legislature's decision to preserve true easements. This case is about something very different. In the most dramatic sense whatsoever, it is about stopping a private scheme that, if validated, becomes a roadmap for any landowner in Michigan to permanently avoid paying real estate property taxes. It's essentially,
It seems like the landowner entered into a very shrewd deal.
the landowner did, you think?
Who's ever not paying the taxes?
Yes, that would be the easement owner.
The easement owner. I'm
Absolutely.
sorry, excuse me.
No, I agree with you. The easement owner,
So why should they be penalized?
they should be penalized, Your Honor, because it essentially destroys the value of the property to any future owner. It eliminates the user's tax liability, and it can significantly reduce the municipality's tax base. But beyond that, in Michigan law,
Those are all policy reasons.
those are all policy, and I
We're not
believe,
here to make policy.
well, the court has plenty of room and has in several cases, has plenty of support for the contention that the court can find an interest void or unenforceable if it's contrary to public policy. But beyond that, just on the straight, we want to just get into easement law. An easement, even an exclusive one, must be a limited, non-possessory use right, not a substitute for ownership. And this situation here, where the easement literally swallows the beneficial use of the property, we have an easement that can clearly be deemed invalid on that basis.
Well, I mean, and I understand your argument about the effect here.
Mhm.
If you just, and I guess, but if you just take the easement on its face, it is for, you know, we do have a limited purpose, right? You can all, it's not like they could do whatever they want with the piece of property that they have these rights to. It's for a billboard. And it isn't for the entirety of the property, though I understand your argument from your client's perspective that it might as well be. But nonetheless, I guess in terms of just the terms of the easement, there seems to be a limited purpose. Am I understanding that correctly?
Well, I mean, I would argue, no, there's 4 easements in that agreement. And it talks about everything over, under, above, around, and across the whole bulk of the parcel.
Well, there's a visibility easement, right?
Right, there's a
an
visibility.
access easement.
Yeah,
And that access, I mean, so that access is just, that's one piece, right?
the access, I mean, it says access of the whole property to get to the billboard. You can't block getting to the billboard in any way, which, no, I have no issue with the fact that it's worded as a limited purpose. In this particular property, and again, this is not something to go against the billboard industry or anything about tax foreclosures taking out their easements across the state of Michigan. It's this particular parcel. There's like a tiny C just around what the bulk of the property because of that easement, and they can't do anything on that. The record shows that the value of that property is 0.
Well, the
to the
property was
owner.
purchased with knowledge of the easement, correct?
Well, the property was also purchased with knowledge that the easement, which is an easement in gross, was assigned, which would normally terminate the easement.
Because of your position that it's not in the limited categories of assignable easements.
There's 2 different things here, Your Honor. So yes, I do agree with that 100%. It is not limited use. And in fact, it's way beyond not limited use. But other than that, also easements in gross under the weight of Michigan law are just not assignable. So they can terminate an assignment. And the cases that say otherwise, and there are plenty, and
Yeah, this is the part that I was talking.
yes,
about.
yes,
There is-
counsel will say there's plenty, but those stem from Johnston, which talks about certain easements with a unique nature. And
Right,
they're
so those are the
all
ones
about
that you don't-
public utilities, which essentially go to the greater good. A billboard sign, it does not.
Has anybody
reach that.
articulated in the case law what you've just said in terms of it has to be sort of for a public good
Well,
for it to be
Johnston,
assignable? Is that articulated in so many words, or is that kind of what you're gleaning from the
from
categories that have been
Johnston, I'm
recognized?
mostly going from Johnston. I do have a list, and we did brief some on easements and gross are not assignable. But Johnston, which is where they all kind of stem from, because it's a 1930s case, right? So it is the one who says
the general rule that easements and gross are unassignable. However, certain easements with a unique nature could be, and they were specifically using that to allow a public utility easement to be assigned.
Yeah, I understand on the record below, and it sounds like you're making an argument specific to this case in terms of the invalidation of the easements. It sounds like it's based on the fact of, I think it's the appraisal report ultimately in terms of the factual record that supports the conclusion that the land is effectively valueless, right?
Correct.
Now, if the opposing side had put in evidence disputing that, and I understand your position that they didn't, but let's say they didn't. So then what happens next? There's a resolution of the value of the land, and at what point does the value become so low that it is that the easement has to be invalidated? I mean, where's the line here?
Well,
and how does that get
right? The easy answer for that, Your Honor, would be a question for the trier of fact. But at this particular case, it is pretty easy because the value has been stated as 0. So we don't have to go into a sliding scale. The value is 0.
I guess I'm not even sure how would a trier of fact make that assessment about what is ultimately, where's the guidance in terms of what, is it anything more than 0?
I love hypotheticals and I can go down them, but I don't need to in this particular case. Would it be anything? There's case law that talks about when you're overburdening the Servian estate. And I guess it's the same reasoning that you would use for any of those. If that's the only thing that you can do on that piece of property, if you're burdening the Servian estate to such an extent that nothing else can be done, or that a significant portion, and yes, a significant portion is undefined, but a significant portion is unusable to the owner, then that would be an invalid easement.
And this is just another factual point, just for clarification. And I think it's in the order on the motion for reconsideration. The court mentions $18,000 that your client had netted through its ownership of the property. I want to make sure I'm understanding what that represents. Can you tell me?
Sure, because when they purchased the property, they went and visited the tenants and said, we now own this property.
Is that all from those initial payments before
Yes, it's
Outfront
all
stopped?
from the lease
That's what that
payments.
18,000 represents. Okay, understood.
And that's why it was cut off 100% at the time. And when they decided, no, they're going to go back to the easement holder. So I do think at the end of the day that this is actually a really narrow case. We're again, not trying to take out things that are established, but this is not a valid easement as it completely destroys the beneficial use of the Servian estate, which is contrary to Michigan law.
Well, that factored in when Harper purchased the property, they thought, well, it's not a valid easement, we'll get it anyway.
Well,
They knew it was subject to the easement, correct?
That's not in the record. So I don't like to speak outside of the record, Your Honor. I don't know what they knew or didn't know, but we certainly had constructive knowledge
It was recorded.
because it was recorded the same way that the easement was, the assignment was. And so also it's an easement in gross, which terminated at the attempted assignment. It can be reversed on those grounds, or is void for public policy, as it was argued by the state of Michigan in a case before this court earlier, the Saginaw.
So where's the state here? Or it sounds like obviously I know you have your client's concerns in mind, but the broader public policy argument you're making is one that, pertains to the public and, the fact that here we're going to end up with a piece of property that nobody's going to want to buy. So it's just going to be reverting to state or local ownership with no tax benefit.
Correct.
But I don't, you've gestured to another case where, we've had those interests represented in an amicus capacity, but they don't appear to be here.
That is true. They are not here, Your Honor.
We know why.
I do not know why. I will mention though, that when this case was coming up, it was also post-COVID. I don't know if it had something to do with that, but honestly, I don't even know if they reached out. I don't know. But I do know that they briefed on almost identical facts in the Saginaw Land Bank Authority case and stated that this is not good for public policy. It's not good for the state of Michigan tax foreclosure statute, and it's against the stated purposes of the General Property Tax Act.
You brought this to the legislature
Well, Your Honor,
or talk to your legislator about it?
we don't want to overturn, the statute itself is fine. The fact that it's not foreclosing on easements is fine. That's not the issue. The issue is this easement on this piece of property. And then the bigger scheme from the legislature, well, then maybe we should go back and talk about that. As, by the way, you realize that the end result of this could be absurd. Anyone, if you just automatically uphold anything that has the label of easement on it, then what is to stop me from buying properties and just selling it immediately to an LLC, creating a residential living easement that covers the entire property for the purpose of renting this property and never paying property taxes on it again? I mean, it cannot be that the legislature intended that anything that just slaps the word easement on it is therefore immune from foreclosure. It means true easements.
Okay. Any questions? All right, you have your final time.
Thank you.
Good afternoon, Your Honors. Fozia Daher on behalf of Appley Outfront Media LLC. At council table is Mr. John Polderman, who is counsel for Outdoor Equities, and we kind of agreed that I would be presenting the bulk of our argument, and to the extent the court has specific questions for Mr. Polderman, he's available, and if he has anything to add after my argument, of course, he's welcome.
Are you from Bob Enright?
Yes.
Okay, so Jim Walsh is no longer doing these cases?
Oh, no, I haven't had the pleasure to work with him. So council came up here and began by saying she's not challenging the act, not challenging the billboard company's rights, but at this core, this is a very straightforward case of statutory interpretation. And I think Judge Reardon hit the nail on the head. Harperland does not dispute, nor can they dispute that under the plain language of the statute MCL 211.78K 5E, that the easement survived the tax foreclosure sale. Looking at that plain language, it says that all property interests are extinguished following a foreclosure, except for certain interests, including a visible or recorded easement or right of way. There's no dispute here that the easement was recorded and that it was visible at the time of foreclosure. And Harperland did have knowledge pursuant to that recording and the visibility. That's really where we believe this court's inquiry begins and ends, with that plain language.
Now, I guess, why does it necessarily end there? I agree it starts there. But I mean, you know, I see the problem that they're talking about, right? I mean, we have an arrangement where, we have an easement holder who has pretty substantial rights to use in a piece of land. We have a record that that shows that the land, as a result, is effectively valueless. And you can correct me if I'm wrong, but I don't see record evidence that's been submitted to indicate otherwise. So we have an arrangement where we have an easement holder who is effectively rendering a piece of property otherwise valueless, but then also does not have to pay property taxes in connection with the use of that land. So I understand you're saying that the statute doesn't prohibit that, and that's fine, but I don't know if that's that doesn't necessarily respond to all of the other arguments that the opposing counsel has made on appeal. So I guess, public policy, why is this something that we should say, yeah, this is within the scope of the legislative intent of the GPTA?
So I have two responses to that. The reason the court's inquiry ends with the plain language of the statute is because under the basic principles of statutory interpretation, public policy is not a reason for invalidating the statute. And I think that's one thing I could have done better in my brief, is go through the authority that says questions regarding the soundness of the policy underlying the statute or the practical effects are questions for the legislator, not the court. I will address those reasons, but this court's duty is to read and interpret the plain language of the statute, and it can't strike down or ignore the language of the statute just because it seems unfair to Harperland.
So
Turning to-
where does that leave the public policy doctrine?
Well, our positions that the public policy doctrine doesn't apply here because they haven't pointed to anything in the statute showing showing an ambiguity or something that would allow the court to go into the next layer of construction, of statutory construction, and allowing the court to look at legislative intent. So that is our academic argument on statutory interpretation.
Isn't there and I think appellate counsel mentioned this, isn't there a absurdity limit on the interpretation of a statute? Justice Scalia and the guy who, I'm trying to think of his name.
Brian Garner.
Brian Garner, I'm sorry. They talk about that, and that's pretty much the handbook now on statutory interpretation.
I don't think this case arises to that. I haven't seen them present that argument in that exact form. Regarding
Counsel makes a good point. This could lead to an absurd result. And she talked about residences, and I was thinking, boy, that'd be a good law practice to get into, making easements to residents. I mean, it could lead to some absurd results. Don't we have a duty there?
We believe that there is not an absurd result here, and there is still a productive use in the property. And that productive use is because there is a tenant paying rent. It's only unproductive because of the zoning laws and how the area is zoned.
Well, I mean, I think it's unproductive for the owner because that tenant is not paying rent to the owner, right? That's the point. And I understand, I mean, and this is where I'd appreciate your help factually speaking, but I've heard it said that there's still productive use and all that sort of stuff. But when I looked back at the record, the primary thing I saw on this point was the appraisal report that said there isn't. And I guess, is there anything in the record to substantiate, factually speaking, the proposition that there is?
Not in my review of the record. And the reason there isn't is because, as I explained, the question in the trial court is whether the easement met the criteria of the statute, whether it was visible and whether it was recorded. And there was no error in the trial court's application of that statute. It's only unproductive to the owner here because of how it was zoned, but none of that information was unknown to them at the time they purchased.
Why does the zoning make it unproductive here? I'm not understanding that.
Because the zoning places certain limitations on what can and can't be at that property. And having a billboard there is really.
But again, I mean, my problem is it seems like an unsubstantiated proposition. Like that's you can't build your record now. And in the trial court, it didn't seem like, and you can choose your path here, right? And just say like, listen, doesn't matter. Doesn't matter because these are legal questions. You have your statute and that's just it. So if you have a piece of property that has no value, too bad, so sad. That's just how it is. Talk to your legislator. And that seems to be the path that your client chose below. So I am having, it seems difficult at this point in your position to have to sort of shift gears from that. And I guess if that's not right, and there is something in the record that tells me that there's another line of argument that's been preserved and presented, let me know. But as far as I can tell, it's strictly legal argument.
Correct.
That assumes the property is valueless, because that is the only factual record that we have on that point is what's been submitted by HLC.
That's correct, Your Honor. The issue below was focused on the legal issues, and we continue to present that same theory on appeal. I think Judge Reardon mentioned this. If counsel has an issue with how the statute is in effect, that's something they can take up with the legislator, or again, looking at how the property is zoned, they can lobby their municipality or find another use for the property, ask for a variance, or argue that the zoning amounts to a taking. They can find some other use for the property, but the statute says what it says.
And I think to the point of unreasonable burden, I think that I think this is from Outfront's briefing, that there's no reason an easement, this is for assignment, that the easement can't be assigned, so long as the additional use is within the scope of the easement and does not unreasonably burden the Servian estate. And I think the argument here is that it does unreasonably burden the Servian estate because it renders it valueless. But how do I know that's wrong? I mean, I'm not sure what's an unreasonable burden on the Servian estate, if not one that eliminates its value.
Our response is that the easement allows certain rights to construct and repair and replace, and it doesn't provide it doesn't provide all-encompassing rights.
So the fact
it doesn't
that
let
just
them do whatever they want.
As a legal matter, regardless of the practicalities, as a legal matter, the fact that it doesn't categorically foreclose those things means that it's not an unreasonable burden, even if practically speaking, the record indicates it does. Is that fair enough?
That's our position.
Okay.
Can I go back to zoning for a second?
Sure.
Isn't the property zoned for industrial use?
I'm gonna be frank with the court. I don't have the zoning facts right before me.
Harper Land Company's
Okay.
appraisal, and it says there that it's zoned for industrial use.
Okay.
So it does have some value, although they admit in the appraisal that it's not easily accessible from the local roadways, and it's in a declining stage of its cycle, its life cycle, whatever that means. I would guess that the property value is going down wherever it's located. And the property value will decrease, but it does have some value as something industrial, it appears. If not for the easement.
If that's what the property is zoned as, then it's on the owner to find a productive use for it. But they didn't know that at the time they purchased the property from the tax foreclosure, so.
They went into it with their eyes wide open. They admitted that. That's on the record. They bought it. They knew the easement was there. And I guess they decided economically they'll fight it out. So here we are.
Yeah, I agree. There's one other point that I want to address. So we noted two cases in our briefing where this court upheld easements based on the statute. Those cases were Global Signal versus Adamo and Outfront versus CHHC. They were both unpublished decisions by this court. If this court rules consistently with those cases and affirming the trial court decision, this will be the third case from this court to uphold an easement based on the statute. If this court is inclined to rule as such, we would invite the court to publish its opinion in this case because we believe it meets the requirements of MCR 7.215 B4 and B5. The issue of easement survival following a tax foreclosure is of significant interest, and it has not been reported in a published decision since 1990.
I mean, how does that square that up with, I mean, it seems like your position is that this is pretty clear. So this is what the statute requires. And so I guess what are we publishing for?
The reason we publish it is because it hasn't been addressed in a published decision yet. And this issue comes up repeatedly for billboard companies in trial courts. You know, that might be only the third time before this court. but out front sees this fact pattern at least 2 to 3 times a year. Someone purchases the piece of land thinking that they own the billboard, or they believe they wiped out a property interest, which is what occurred here, despite a recorded and visible easement. Publishing this decision will provide much needed guidance and clarity to those property owners, and will hopefully prevent these kinds of lawsuits from coming in the first place, especially where we believe the statute is so clear cut. And the landowner's objections in these types of cases always end up relying on policy reasons or alternate arguments beyond the statute to invalidate the easement. The facts in this case are also a good vehicle for publication because they are very straightforward and clear cut. And the court's ruling would easily be transferred to other types of cases. So I'm happy to submit a publication request following the court's opinion, but I did want to flag that for the panel prior to the opinion being released.
It's interesting that Judge Mariani was on global signals, so who knows?
So I'll rely on my briefing for the rest of the arguments unless the panel has any additional questions that I can help with.
I don't think any more from me.
Thank you.
Thank you very much. Nice job. Rebuttal? Or you, oh, sorry, the other side.
Upfront media.
So let me figure out how much time you have. Hang on. I'll be brief. No, I still want to keep track. Part of my job here. You got about 15 minutes.
Thank
So
you, Your
be
Honor.
brief though. Not, you don't need to use the whole 15.
Sure. John Polderman on behalf of Outdoor Equities. I just wanted to respond to a couple of questions that I heard, one of them being the distinction between value and use. So there's this question that was posed that the land is now valueless based on this appraisal that was submitted in the lower record and not rebutted. But there's a distinction between value of the land and use of the land. The easement is limited in scope, it's subject to this billboard. The parcel is larger than just the billboard, and the owner can use it. He could put a chair out there, he could put a dog kennel out there, he could do whatever he wanted.
Is any of
with
that
it.
substantiated in the record, counsel?
There is no argument either way on use of the property. There's argument on the appraisal as far as the value, but I'm unaware of anything in the record that said I cannot use this parcel, period. There's the appraisal that says, well, it has little value because of this billboard there. And make no mistake about it. And I think this is in the record. This is an issue with the billboard. The Harper Land purchased this property at tax sale, subject to the easement, for the hopes of getting the billboard revenue, and in fact did get some of the billboard revenue until my client stopped back in. This isn't, and there's nothing in the record that would say, I wanted to build an industrial building. I wanted to expand into the lot next door. I wanted
Make a difference though.
Pardon?
Does it make a difference or motivation in purchasing it?
It does not. It does not make a difference, but when we're talking about value and use, he still has the right to use the parcel subject to the easement.
Your client didn't do an appraisal of the property, correct?
He did not. I mean, we stuck, I mean, there was competing motions for summary disposition, and our point was there's no issue of material fact because the statute is clear cut. So there wasn't like there was an evidentiary hearing or a trial or even an opportunity to have a hearing on the value of the property because it rose by summary disposition, and we said there's no material fact. The statute controls, we have an easement.
Right. There was an opportunity. You just chose how you were going to take advantage of that.
That is true. That is true. And then lastly, I wanted to address this issue of reaching an absurd result if the court were to rule in our favor. Of course, nobody can predict what future cases would be brought or how persons would react in the future, but there's been 2 prior decisions of this court that are unpublished on similar facts with an easement that was upheld after a tax foreclosure. And the owner of the parcel has made a decision to purchase this at tax foreclosure sale and to pay taxes on it or not. This wasn't secret. It wasn't hidden. And if parties believe there's a loophole, to the court's prior point, then the legislature is the avenue and the venue to fix it. We would reach a similar absurd result of saying, well, because there was an appraisal that the parcel was worthless. Well, what if there was an appraisal that said it was worth $1 or 50 cents? There's no bright line as far as valuation or what leads to something that's valueless. Or what if the parcel was 50 square feet or 100 square feet, right? Those are arguments that would be made in or considerations in enacting the law, but not necessarily applying it as written.
I'm sorry, counsel. Why was this, I'll ask you as well, why was this not an unreasonable burden? Based on the record we have.
I guess I would go back to my distinction between value and use, because the easement is limited in scope to the billboard and to accessing the billboard. The owner still has use of the parcel. The billboard doesn't cover the entire parcel. So it's
So the fact that it's a limited, I mean, it sounds just the fact that the easement is, has on its face at least, limitations in scope, is adequate to show it's not an unreasonable burden. It's more, you don't really look at the practical effect.
Well, I think even if we looked at the practical effect, the parcel of land is not just the size of the billboard pole, right? That would, I think.
But then I mean,
right,
you're getting into fee simple territory.
Right. We would move into kind of the absurd result where the easement effectively, it covers the entire parcel. But that's not the case here. The parcel is substantially larger than just the billboard. So in that regards, it doesn't unduly burden the parcel. It's not as if the owner can't access it or can't, do what he would like. I guess he would be prevented from barring access to the billboard or tearing down the billboard. Those are the two things that clearly he would not be able to do. And my client is able to access it.
Well, there's also a visibility. You can't.
Well, that's true. You can't construct a structure around it, rendering it invisible. That is true.
Nothing more for me.
I think, Mr. Puller, thank you very much.
Thank you, Aaron.
Thank you. This has been very fun, so I appreciate all the engagement. It's been super fun.
We find that the whole day has been very exciting.
Yeah, it has been actually. I have been here and enjoying every single bit of it. I did want to respond to a couple things though. So first, opposing counsel got up here and spoke a lot about statutory construction. The problem being here that is trying to say that we're trying to invalidate the statute. We are not. That's why I opened. We are not trying to invalidate the tax foreclosure statute. We're trying to invalidate this easement.
Well,
I'm sorry, go ahead.
If you were arguing that the results of the statute, they're absurd. So that's tantamount to invalidating the statute.
In this case, if the court.
In any other case like this.
I do agree with that 100%. I think I was telling this.
We are invalidating the statute.
I don't think you're invalidating the statute, Your Honor. You're saying that the statute says true easements. You're saying that the statute allows easements to go by and that Michigan law defines easements and in a separate way allows you to invalidate an easement. And if it's an invalid easement, it's not in the statute. And I think that's a fair interpretation. I don't know that you have to say a valid easement and every time you're talking about something that already has a meaning under Michigan law.
I mean, I think I understand your sort of, as applied kind of argument, but, presumably in your view, does it, how dependent is it on this $0 valuation?
Well,
that is huge. That shows that it is incredibly burdening the surveying estate, which allows you to just invalidate that on this purpose too. I did want to mention and call out a couple things though on the basis of use versus value. When you look at the easement agreement, it has 4 easements in it. Only the first one, which is the structure easement, has a defined property. The other 3, the access, the utility, and the visibility, are over the entire area of the property. So I don't want to fool ourselves there either, just because there's one part. I'm not sure how much you could use that and not interfere with anything else that they say that they have going on. So there is that as well. But yes, if you're talking about overburdening a surveying estate, making it not able to be used, of no value, not able to do any other improvement to it, not able to sell it, who's going to buy this?
Well, your client.
Well, yes, they bought it because they consider that easement to be unassignable. It's an easement in
Roll the
gross.
dice.
They did roll the dice, Your Honor.
I
Doesn't mean
will
that they
say
can't
this,
fight
You
it.
have a tough hill to climb with the absurdity doctor because that's very disfavored, at least in my view.
I understand what you're saying.
You're asking us to rewrite the legislature, substitute our, I guess, to make a call that legislature totally disregarded these scenarios. I don't know. That's a pretty tough hurdle.
Well, I'm backed by the state of Michigan and their brief for selling on a
State of
land
Michigan,
bank.
that's another branch of government that's backing you.
Right, but I don't think,
That's the executive, that's the legislature.
and to say that there is something that that is why the judicial system exists, right? To make sense of things that might otherwise
Not to
not be
make
made sense
it's to
of.
follow the law. That's why we exist. What does the law say? That's in my view, that's why we exist.
I do agree
Not
with
to
you
make
there,
the
Your
law
Honor.
up.
But I do think that there's a certain amount of interpretation that you do. I also believe that this is kind of under Michigan law, easy to rule that the easement is invalid. So, okay, it survived. It's still invalid. So I do believe that that is very important. And also just a couple things on the differentiating cases, Global Signal and the CCHH, because those are 2 good cases, but those are also very different. When you look at Global Signal, it was 523 feet of a much larger parcel. And it was for a public utility. And in CHHC, or the Outfront Media one that was just more recently ruled on, they weren't arguing what Harper Land is arguing. They actually were trying to say that because it says easement and right of way, that had to be one and the same. And I don't believe in that either. So I believe that this court was correct. But in this particular case, this is not an easement. It's a perpetual private revenue interest masquerading as an easement, and it destroys the land's value. It defeats the GPTA, and it violates the core easement doctrine.
Thank you very much.
Good,
Well
thank
argued
you.
by both of you.
Yes, thank you.
That
Thank you.
was all the
Your Honor.
makings of an interesting law review article.
It really was.
Case is submitted.
If it would please the court, Neil.
Hang on for a second, I gotta call your case.
I'm sorry.
Oh, you can stay up here if you want. I'm just gonna wait for counsel to move a little bit. Okay, calling number 28 on our docket, case number 373-820. Precision Standard Incorporated versus ADP Tax Services Incorporated. Counsel, identify yourself now.
If it would please the court, Neil Newschultz on behalf of Precision Standard Incorporated.
Welcome.
Thank you, Your Honor. This case involved a payroll agent agreement that was entered in June of 2020, and by August 11th of 2021, ADP had collected $250,000 and decided not to pay the Precision's payroll taxes with that money.
So you're calling it conversion?
That's common law conversion when they.
Seems to me it's a contract case.
Yeah.
It's conversion because it appears they used the money for their own purposes, which is statutory conversion. It's also conversion when they decided.
Didn't use it the way according to they didn't use it in a way according to the contract you entered with them. Is that correct?
That's true, but they must have done something else with it because when they decided not to pay it, they should have returned it to Precision. They should have just paid
But
the
they
money to
ultimately
Precision.
paid it, right?
I'm sorry.
They ultimately paid it, right?
Ultimately paid it slowly and refused to tell us why they were paying it. And the reason they did that was because if they had disclosed to us that they hadn't paid it under jury instructions in Michigan, and we had said to them, well, if you haven't paid it, give us the money back, and they didn't give us the money back, then that would be conversion. There's a jury instruction that if you demand the money that's converted and it's not paid back, that's conversion. So the reason that they did that was to pay it slowly. And each time they did that, they'd send a check. The bookkeeper would say, I need to know how to account for this money. What is it? And they would say, you can deposit it. And they wouldn't tell us that they hadn't paid the taxes, that they hadn't filed payroll tax returns, that they hadn't done anything. After 8 months, they finally, I think after they finally paid the money back, they finally disclosed what they had done, that they had not filed payroll tax returns. They in fact never paid the taxes because the money was paid back to Precision, who ultimately ended up paying its own taxes.
So isn't that, as Judge Reardon just stated, your allegation is really that they negligently performed their obligations underneath the contract?
No,
Not tort theories.
well, the two tort theories are, one is that they used the money for their own purposes, which is statutory conversion, and also that they decided not to pay the taxes and didn't return the money to Precision right away. They waited, they did it slowly so that they could argue that they had returned it under circumstances where they would not have disclosed that they hadn't paid the taxes or filed the tax returns. And the other tort that is involved is the breach of a fiduciary duty, that they're an agent, they're a payroll agent, and the Precision is saying to them, why are you paying money back? And they're not telling them why they're paying the money back. So that's the second tort. So there's two torts. There's statutory, there's three. There's common law conversion when they decide not to pay the taxes and don't return the money. And I've cited a case on that in my brief. The Citizens Insurance says, if you create an involuntary debtor-creditor relationship, that's conversion. That's common law conversion. And then in paragraph 26 or 26 of my complaint, I've alleged that they use the funds for their own purposes, and that's statutory conversion. And in paragraph 14, I've alleged that their failure to disclose to us.
Citizens involved a check, not a
Right,
contract.
it wasn't, but they kept the whole check instead of
Not a
return.
contract.
It wasn't a
All
contract.
right, you got an interesting case. I think we understand it.
Oh,
You
okay.
can argue all you want, but I think we
Well,
understand it.
Okay, it's not clear to me why the conversion claim is not a separate duty distinct from the contract. The lower court didn't really explain that, and I haven't gotten anything from the other side that explains to me why it's not a separate duty to not use the money for your own purposes and not to disclose what you have done with a payroll tax return. So it seemed like separate duties to me. So I've never really understood how the lower court could call those not being separate duties. And I've not seen anything from the other side that explains that to me.
You have what's your best, do you have
I have
if it's in the
one.
brief, is there a case that says like, we have this contract that is the
Right.
basis of this relationship?
Well,
And your statutory conversion arising.
right. I have two responses to that. One is the rebath bathtub case relied on by the court. In that case, the 1-800 rebath had leased the phone number to the other company and said, you can't steal the number. The number was stolen, and they sued for conversion. And the Court of Appeals said, all that you've done here is you're suing for a breach of the specific provision of the contract that said you could not. So that was a specific provision of the contract which stated you couldn't steal the number, and they sued them for conversion. So that is one case. The other case, to address your cases, is language in the Loeki case about misfeasance, and I'll quote that. The Michigan Supreme Court. This court had described a tort action arising from the misfeasance of contractual obligations as a violation of a legal duty separate and distinct from the contractual obligation. So I'm claiming there's a tort here that resulted from them their misfeasance of a contractual obligation was that they took the money, they didn't pay the taxes, and they took the money and used it for their own purposes. So that's in the Lowicki case. So those would be my two responses to your question.
In Rebath, didn't the Court of Appeals hold the conversion claim is barred because the conversion claim does not impose duties separate and distinct from
Right.
duties existing?
That's exactly correct. And that, but it was in the contract. It said you can't steal the number, and then they sued them for stealing the number. And they said all you're doing is creating a tort out of the non-performance of a provision of a contract, which is.
And here we have a non-performance of a provision of a contract.
But there's an additional factor, and that is not only did they not pay the taxes, they used it for their own purposes, and that's alleged in the complaint. And then there's an additional, which is the failure to disclose the agent violation, the breach of a fiduciary duty, is also should be separate and distinct from the contract. Any other questions?
No, nothing further. Thank you, Council.
Thank you very
Thank
much.
you.
Good afternoon, Your Honors. Mark Steiner on behalf of ADP Tax. I will keep my response very brief. It's very clear that Your Honors have read the briefs and understand the issues involved here. Our position
That
is
makes us feel good.
our position is that it's very clear the allegations all stem from either an alleged negligent failure to pay taxes and file returns, or the failure to do so, both of which is what the services under the payroll agreement specifies ADP Tax to actually do.
Okay, but what, I guess, tell me about opposing counsel's point that this isn't just a matter of failure to perform, but it's actually a act of misfeasance in connection with that failure to perform that gives rise to a separate cause of action.
So
Why is that wrong?
So there's two cases that come to mind that discuss the misfeasance issues. One is the Ronaldo's case, and one is the Lowicki case that brother counsel referenced. In Ronaldo's, it described misfeasance as essentially duties that arise outside of the contract. And actually, Lowicki is a good example of how that may occur. In Lowicki, it was a contractor and a subcontractor that had an arrangement for some construction relationship. In that case, it was actually a personal injury case where one of the subcontractor's employees caused harm to someone passing by. And it was essentially a personal injury action because that negligence had nothing to do with the contract. That the duty arose outside of the contract because he essentially was acting not with care in accordance with his general negligence duties. It had nothing to do with the contract. That's not what we're talking about here. Here, ADP Tax had a contract with Precision to essentially pay these taxes or and file returns and handle the payroll. That's essentially what we're talking. That's all we're talking about here. And I'm not saying that the allegations that counsel raises in its complaint cannot come to any sort of cause of action. That's not what we're saying at all. It's just simply a breach of contract action in which we would have certain defenses by the contract. That's why contracts exist.
What a theft cause of action. Well, that a civil cause of action, how about referring it to a prosecutor, please?
That's a little bit outside the scope of the briefing, I think, but I think the point is
We
also.
still have a contract. Would your defense be, well, it's a contract, it's not theft?
I'm not a criminal law attorney. I apologize. I can't answer that question and what the criminal ramifications would be. But what I can say in this
But
particular
you are
case.
saying that there can't be another civil action.
Correct. I mean, as far as I understand, the civil action would be a conversion count, which has been consistently ruled upon in this type of situation, whether it's Rebath, whether it's Ronaldo's, whether there's Shri and other case law that says very specifically these are contractual duties. I also want to point out, we're not talking about the $250,000 that was actually paid to the government for the taxes. Counsel has alleged damages stemming from his own fees that occurred after the taxes were paid to confirm that taxes and returns were actually filed. So there really hasn't been any conversion or theft here
at all because the government has been fully paid and reimbursed with all fees, interests, and expenses. That's in the complaint. That's been stipulated to multiple times on the record. All we're talking about is approximately $10,000 of fees that occurred after the taxes and returns were submitted to the government to confirm that they were actually submitted correctly. So with that, Your Honor, if you have any questions, additional, I'm happy to answer them. Other than that,
Nothing further from me.
Thank you very much.
Thank
you.
You have some rebuttal time.
I just would point out that it's not true that the fees occurred after everything was paid. A good portion of the fees were the result of tracking all the funds that had been taken by ADP and then given back, and then making sure that they were paid, that the returns were filed. So
But counsel, I guess I understand your timing point, but how does that make those damages sounding conversion anymore?
No, it doesn't change a thing. I mean, but the fees were the result of monitoring ADP, trying to figure out where the money, because they had sent these small checks back over time.
Right, but how are those, I mean, how did
It
those
doesn't change. I agree with you.
But I don't know if you're going to agree with me here, but how are those damages, how do those sound in conversion?
Or they're the result of them taking the money and using it for their own purposes, and then not disclosing to us because as I indicated in the brief, what I think ADP was doing was taking money from one customer, investing it long-term somewhere else, and then using future payments from other customers to pay that customer back. Because why not pay the whole thing on day one? Why not pay the whole $250,000 back if they have the money? So it looks like they're waiting till the new money, fresh money comes in from other customers to pay them back. So because of that, it imposed upon us the obligation of figuring out whether all the money that they had paid back was equal to all the money that they had taken.
So the issue I have, counsel, with what you're saying is that there's no record evidence of that.
There's nothing in the record other than the statements by the accountant, Sabina Bravo Persons, who said that she had gone through all of the things and had counted every time they sent a check, she would say to them, "What is this check for?" So she could account for it. But it's true, the checks are not on the record. And anyway,
Yeah. And there's also a consequential damages claim as it relates to the 10,000, the professional fees for the accountant and the attorney that you hired.
Right.
Yeah. So.
Well, you do get incidental damages under the conversion statute. That's
if
laid out in
there's
the brief.
conversion. Yeah, I understand your position.
Well, if there was a security involved here, you just described a Ponzi scheme.
That's what it looks like to me.
There's no security.
No, nothing more for me.
Thank you
All right,
very much.
thank you both. Thank you.
Thanks, counsel.
Case is submitted. I think we're down to our last oral argument of the day. Okay, calling case number 29 on our docket. Jeremy Nielsen versus Jonathan Savino.
Good afternoon. May it please the court, Richard M. Delanis appearing on behalf of plaintiff appellant Jeremy Nielsen. This is a case about fundamental procedural fairness and due process. The issues are pretty straightforward. We have a trial court that dismissed the complaint based on an affirmative defense that it raised sua sponte that had not been raised by the defendants. In lieu of filing their answer, they filed a motion
Usually
for.
fences make good neighbors, but
I knew that would come out here, yes.
my only joke of the day.
That's right.
You get one.
There it is. That's right. So they filed their motion for summary disposition based on several arguments. One was that they thought that the CC&Rs were ambiguous. The other one was estoppel and waiver, citing the fact that, hey, the HOA gave us approval here. We're done. Can't do anything about it. We're good. We've relied on that. To the extent that the fence doesn't conform, we got a variance. So this case needs to be dismissed. We responded to that, Discovery was still ongoing. We were in the process of getting a survey to establish how this fence was not conforming to the restrictions. The court, without oral argument, dispensed with that, entered its opinion in order, granting the motion, saying latches, guys, that's the argument, latches, you're done. Court doesn't articulate any prejudice in the opinion, but basically suggests that the delay itself was the prejudice. That's not the standard under Michigan law. If that were going to be actually have been raised as a defense, first of all, the defendant would have to show that there was in fact such a prejudice of such a character that the claim should be dismissed. Typically in a latches case, we may see where spoliation of evidence, a death of a key witness,
Well, it's
something like
prejudice
that.
resulting from the delay itself.
Correct. That would be true. So for example, if there was a key witness, let's say there was a board member that was key to this whole thing and had died and is no longer available to present testimony, that would be a potential latches case. But of course, they didn't even raise latches to begin with. It was
Raised sua sponte by the court.
by the court. That's right.
You made a great argument for latches in your brief, so your brief was pretty well done.
Okay. So we've got that. Then we've got, of course, discovery was ongoing. The court criticized us to some extent in the opinion, saying, you don't even have a survey. Well, we were getting one. We didn't even have the opportunity to get to the close of discovery. Discovery was going to close on October the 14th. The court entered its opinion in August. We had outstanding interrogatory answers coming our way, all of that. So we've got a case here that was certainly not ripe for summary disposition, both from an affirmative defense and a procedural issue, but also with respect to the fact that discovery had not closed. And we did put in to our brief the very issues of fact that we believe were disputed, and we presented evidence for that in our attachments. For example, there was an affidavit of the former president of the HOA saying, oh, yeah, I approve this. Well, there was board minutes and also an email that went out to members that said, oh, in 2017, I didn't approve any fence. So there was a conflict there. Had no ability, of course, under the circumstance and how this case went, to even ask him about that. But we did point that out to the trial court, who disregarded it and shouldn't have.
And counsel, just so I make sure I just understand the basics of your position, it's that, the latches point aside. I mean, I know that your client disputes whether there was, I guess whether the subsequent HOA approval was valid. But then it's also the position that regardless of any approvals, your client still gets to challenge conformity with the actual restrictions.
Correct.
Even if the HOA board said this was okay, he still gets to come in and say, they are wrong about that, and I get to challenge it because the CC&Rs say I can.
That's right. And it's a covenant running with the land, which means every lot owner in that subdivision has that exact same right. And typically you would hope that the HOA does their job. When the plans come into the Architectural Control Committee, they look at it. One of the first things they do, of course, is look at aesthetics. Does this fit what we want to see here? And then they are supposed to indeed vet it to make sure it meets the requirements of the CC&Rs, which we say it didn't here. Now, there was one document below attached to our response that indicated that there was some type of written approval from a gentleman from the control committee. And in there, he said the approval was conditioned upon that the fact that the fence would conform. It did not. We think we can, in fact, prove that below. We just need to be given that opportunity. That's why we're asking for the remand.
Okay, wait. Do we have any
Oh, I
questions?
don't have anybody. Thank you.
Nothing further from.
Okay, now you can sit down.
Hello, Katie Savino, on behalf of both myself and my husband. Couple things I want to address before I get into my argument here. What was just stated on the record. An email was referenced stating that a former HOA president did not approve it, while in the same time, the former HOA president signed a document saying he did prove it. And then that email was later to be, in my brief to the circuit court, was shown to have been in a draft, and things were in error in that. There was a second draft of that email that wasn't produced. So things were getting picked and choose
The gentleman who's suing myself and my husband is the current president of the HOA, has access to all of the books and was able to pull whatever he wanted, whenever he wanted from these books. So the fact, going back to the discovery issue, discovery was opened. The complaint was filed in March of 2024. The answer to my motion for summary disposition was not filed until May 22nd of 2024. Discovery didn't close until October. The survey could have been done in 2017, 18, 19, 20, 21, 22. You get the picture. It was never done. The thing is, it
wasn't done, but are there additional costs? So let's say if the judge said, remove that fence, what additional costs, what additional harm is done to you? If they tell you 6.5 years after the fact or the day?
Absolutely. Absolutely. I think it's a great question. I would have to purchase new material or dispose of the material that I already purchased. We'd have to hire a contractor to come out.
You have to hire a contractor anyway. You'd have to dispose of material.
Yep, absolutely.
Those are all costs that you'd have no matter what the timing is.
Yeah, yes, there would be costs, absolutely, if I had to move the fence. Is that what you're asking?
That's what I'm saying.
Okay, yes. And that was what I'm saying would be the prejudice to us.
But that
Would be removing the fence or moving the fence. I'm sorry, go ahead.
Yeah, but that, I guess what we're wondering is when you're talking about latches and.
Yep.
Is,
Go ahead.
if we're talking about latches, we're not talking about just whether there's any prejudice from you having to do something. It's whether there's any additional prejudice from the fact that you have to do it later than maybe you otherwise could have. So here, what I'm hearing is to replace the fence costs money. But what I'm not hearing and what I don't see anywhere in the briefing or in the record is anything that says the cost of that is different now than it would have been if I had to do it 6 years ago.
Well, I think we all know the cost of living has gone up significantly. So the cost of purchasing new material, matching the fence, moving the fence, doing things like that would have been significantly lower back when I did it.
Is there anything in the record to substantiate it?
No, I don't believe there was, other than the cost of what the fence cost at the time. I don't have anything what the cost would be now, but I would have had to purchase less material. If their argument, which they have multiple arguments, they say that you can't have fences. They say that they have to be a certain distance from the back. Then they say that they can't enclose the rear lot line, all of which is contradicted in the two first 9.06 in this DCCNRs, and then the amendment removes that you can't fully enclose the rear lot line, which was my original argument that they are vague and ambiguous, which is why it was admitted by the plaintiff at a board meeting that they were vague and ambiguous and that they were going to go and get a legal opinion to clear it up on a new fence issue in the neighborhood. That was clear. It's on record. It's on a video of him saying it's vague and ambiguous. And that's because some things are changed in the amendment. Some things are removed from the amendment. They argue that the amendment is actually a supplement. They don't even call it the legal opinion says it's a supplement. So how are you supposed to know where the lot lines are supposed to, not the lot lines, where the setbacks are supposed to go if it's not in the first 9.06, but it's in the second 9.06, the amendment? You don't have to have it. You can't fully enclose the rear lot is only in the amendment, not in the original. And approval is actually only when required is noted in the amendment. So when is it required? It's not in that was changed in the amendment. So there's a lot of things that create this vague and ambiguous 9.06 that are being relied on here. But the main issue here is that the fence was approved. It was approved in writing. This was a C10 motion and there was no evidence otherwise. I think any type of additional discovery should have been done. A survey could have been done, which by the way, the survey has been done without anybody contacting me. I mean, they came to the property, they did the survey. It's not going to change anything. It shows exactly what the record already shows. We have the results of the survey. It's not in the record, this record, but they have it. They know what it's going to do and it's not going to change anything. It shows exactly what I have laid out in both my original record and in the brief. The fence is and was approved by the board and there was no evidence otherwise, other than an email that was later shown to be an error, written in error.
But I understand their position to be, even if the board approved it, he can still challenge it on the basis that it does not, that the board did not approve it correctly. It does not comply with the regulations that it has to. I understand you disagree. But my understanding is there's the matter of approval, but then there's also this separate matter that kind of exists apart from it.
Right, which then I think you would need to go after the board. The board is the one who approved it in good faith. They went in and they approved it, just as all the other fences in the neighborhood that have been put up that don't conform. And they're only coming after me. And there's,
Well, I mean, they can't get relief from the fence
Right.
from the board, right? What they're looking for is relief from the fence, so they have to sue
Right.
presumably the person who owns it.
right, which it doesn't even make sense why we're here today to ask for this. It's not in anyone's view. It was approved by the board. I relied on that approval to change it this many years later when this individual was in the neighborhood and could have objected to it all that time. Does cause significant delay and, I mean, effort and work that was put in that would have to, we talked about this already, to be the cost.
Okay.
So.
Any questions?
No, nothing further from me.
Thank you very much. Well,
Thank
you.
you.
Mr. Delonis?
Yes, just briefly. What you heard in regard to the issues of ambiguity, none of that, of course, is in the trial court opinion. Trial courts really relied on latches. And in regard to the compliance of the fence, at the end of her opinion, Judge Grant actually court acknowledges that the HOA approved a fence in 2017, which may not have complied with the applicable CCNR. So question of fact, that needs to be developed. There absolutely is a dispute with respect to that issue.
Well, any questions?
No, nothing further.
Thank you very much. Case is submitted. Calling last case on our docket, number 30-374-627, N. Ray K.D. Brooks Miners. There being nobody endorsed, that case is submitted. That concludes our case call for today. Thank you all for staying here all day.
Yeah, thank you.